So from rules 1 going up. And our first group will be from the class of Attorney Banoan, 1E, Miss Co, Miss Castellon, and Miss Lado. Thank you, Miss Co, Miss Castellon, and Miss Lado. You can start now. Thank you.
Good afternoon, everyone. So for today, our group will be presenting our proposed amendment for Rule 101 of the Code of Professional Responsibility. Next slide, please. So we'll first start off with the problem that we see with Rule 1.01 with how it is today. So currently, the rule is used to discipline lawyers for non-professional misconduct. Because of this rule, lawyers are expected to maintain a high standard of legal proficiency, morality, and integrity. As a result, they are disciplined even if they are acting in their private capacity, or in other words, what is being disciplined here is the gross misconduct outside of their professional capacity. However, there still remains issues. First, with the ambiguity between such actions made in their private and in their professional capacities. And secondly, issues with the constitutionality of the punishments based on the rule. By determining the constitutionality of such punishments imposed, our group aims to draw the line between the valid regulation of a profession and a lawyer's private interests and individual rights. In doing so, our group here advocates for a liberal interpretation of Rule 1.01 such that the code does not overstep into areas that should be constitutionally protected. Next slide. Our proposed amendment is by adding a qualifying sentence to the provision of Rule 1.01 to further emphasize that there should be a difference in treating or disciplining the actions of a lawyer, whether or not they were done in the private or in their professional capacities. So this amendment reads, such conduct shall not be punished if it is unrelated to the practice of law, unless the misconduct manifests their wanting in moral character, honesty, probity and good demeanor, or unworthiness to continue as an officer of the court. Next slide.
Thank you for the introduction, Julia. Now, it is established that the Supreme Court has punished lawyers for non-professional misconduct that was deemed to be grossly immoral. But the focus of our group today is on infidelity. As we all know, the court has time and time again punished lawyers who are unfaithful because such conduct, though the lawyer acts in their private capacity, shows gross immorality and somehow an unworthiness to continue practicing law. For example, in the case of Tumbaga versus Teocson, Attorney Teocson was suspended from the practice of law for 3 years because he engaged in an extramarital affair and begat a son with someone who sought legal advice from him. Along with refusing to support them, this constituted gross immorality and thus a violation of Rule 1.01. The court here reminded that lawyers should not only refrain from adulterous relationships or keeping mistresses, but also avoid acts that may scandalize the public. So in this case, we see an attorney entering into a relationship with someone that he had a legal relationship with. Thus, for our group, this case is actually one that may be subject to disciplinary action because having an extramarital affair with someone who sought legal advice from that lawyer may reflect on the lawyer's handling of their profession. However, there has to be a distinction between misconduct that can affect one's ability to practice law and misconduct that does not. For example, in the case of Figueroa versus Barranco, the court decided that Barranco should still be allowed to take the lawyer's oath because even if his premarital relations with the complainant and his promises to marry her suggest a doubtful moral character on his part, those do not constitute grossly immoral conduct. Also, in Uy versus Bonifacio, a disbarment complaint was filed against Bonifacio for allegedly engaging in an immoral relationship with a married man. However, in this case, the Supreme Court dismissed the complaint against her because, one, she didn't know that the man was married, and two, when she knew of his marital status, she immediately left him. So it must be noted here that the latter two cases presented are an exception to the general rule that the Supreme Court usually metes out punishment to lawyers for engaging in extramarital affairs. Usually, in punishing such conduct, the Supreme Court seeks to protect and promote both the public good and the dignity of the profession. However, as will be shortly discussed, the group argues that there must be a distinction made between conduct that will affect a lawyer's ability to practice law and conduct that does not.
Thank you for that, Audrey. And now we will lay down the constitutional arguments against the punishment of non-professional misconduct. The first argument is right to privacy. Next slide, please. And in our jurisdiction, the court has declared that our constitution recognizes and protects zones of privacy. However, the right to privacy is not an absolute right, and as a general exception, the right to privacy may be restricted when there is a compelling state interest. And other commonly recognized permissible intrusions are when an individual is a public figure, and in the context of public employer intrusions, the privacy interests of government employees. And taking those into consideration, there's a perceived both breach into a lawyer's right to privacy when they are punished for conduct done in their private capacities. First, lawyers are not like public figures in the sense that their affairs do not give the general public a legitimate interest in all their affairs. While they commit such acts, they are not doing it as lawyers, but as private individuals. Secondly, even if lawyers are to be treated like public figures because of the public character of their services, then a lawyer must be punished only for acts in connection with their profession. Third, applying the clear and present danger test, there is no clear and present danger of a substantive evil that the government has a right to prevent when a lawyer commits immoral conduct of a private nature. Lastly, applying the balancing of interests test, the individual or right or interest of a lawyer to remain in the profession must trump the alleged threat of public hostility to the administration of justice. And in conclusion, if lawyers can be punished for conduct of a private character, then the right to privacy will be rendered illusory. Next slide, please. Next is the right to equal protection, and this provision has been constantly held to be accorded to every person under circumstances which if is not identical or analogous. For lawyers, according to applications of Rule 1.01, they may be disciplined for misconduct committed either in their professional or private capacity. And the test to determine whether the court can discipline them is whether a lawyer's conduct manifests their wanting in moral character, honesty, probity, and good demeanor or unworthiness to continue as an officer of the court. However, jurisprudence in the Philippines has barely distinguished whether or not the specific misconduct that constitutes a violation of Rule 1.01 manifests their wanting in moral character. Courts in the United States of America further discern the test to ascertain whether or not a lawyer may be disciplined for conduct not done in his professional capacity. And their court asks two questions. First, whether or not the misconduct reveals a flaw in one's personality, and second, whether or not it would manifest in his professional life. Um, Comparing lawyers to other professions, say public officials, a final conviction for a crime is not enough to be disqualified as a candidate. And if we subscribe to the view that lawyers and public officials are alike, as they are supposed to both administer and promote the law in high regard, they should be treated similarly. And yet, with regard to public officials, the list for disqualification from public office is exclusive. And with lawyers, what may disqualify them from practicing the profession is not only not exclusive, but also ambiguous, as we will be discussed in the following right, which is the right to due process. Next slide, please. And this right is secured for every person under the Constitution. Two doctrines are used to ensure that the law complies with due process. First is the void for vagueness, and second is the overbreadth doctrine. First, under the void for vagueness doctrine, an enactment is void if men of common intelligence necessarily have to guess at its meaning and differ in its application. And such vagueness is present in the current application of the rule. And as noted earlier, it ignores the line between the actions of a lawyer that are done in a private and public capacity. Lawyers will still fall within the scope of the right to privacy and are thus entitled to a reasonable expectation of privacy. And lastly, the overbreadth doctrine. An enactment is void if it is broad and it unnecessarily sweeps certain guaranteed freedoms. And such lawyers are lumped together with other guilty attorneys whose actions have actually interfered with their duties and have harmed public interest in some way. And allowing the rule to operate as it is will sweep over the protected conduct of lawyers who are entitled to the right to privacy and other cognate freedoms.
Thank you for that, Cheska. So all in all, there is a line to be drawn when applying Rule 1.01 of the Code of Professional Responsibility. To reiterate, what our group sets forth is that lawyers shall not be disciplined for misconduct committed in their private capacities. Such conduct does not affect their personalities or performances as attorneys in law, nor would this conduct cause them to violate their obligations to their clients, the courts, or fellow attorneys. In essence, the court can rightly intrude on a lawyer's privacy as long as the same lawyers are accorded the protection provided by the equal protections of the laws as well as the due process. What we want to emphasize here is that certain actions punished through the RPC and special penal laws should be administratively punished only if the accused has already been convicted of the crime. Otherwise, such conduct remains unsubstantiated by any kind of evidence, and so the utmost respect for constitutionally guaranteed rights must and shall always prevail. Next slide. That is it for our presentation. Thank you very much for listening.
Thank you, Ms. Ko, Ms. Castellon, and Ms. Lado on the presentation, I'm Moral, Immoral, the fine line between lawyers' immorality and dishonesty and the protection of constitutional rights. On to the next group of Messrs. Arranca, Banta, Juan, Miss Juan, Mr. Piad, and Mr. Sandoval on civic duties of today's lawyers, transcending the shortfalls of Canon 1. This is from the group of class of Professor Banyas. Presentation, please.
We examined Canon 1 of the Code of Professional Responsibility and determined that it calls for several modifications to remain relevant in establishing a lawyer's role in society. We identified certain deficiencies here. First, we find that Canon 1 should not be stated primarily in negative form, where it merely sets prohibitions and limitations. Instead, we suggest that changing the syntax into positive language will better reinforce compliance to Canon 1 and emphasize the crucial role of lawyers in society. As a comparison, the Code of Ethics of the Philippine Medical Association and the Code of Ethics of Professional Teachers are written in positive form. Next, we find that Canon 1 suffers from being too broad and general. While we recognize the intention of the framers to make it broad enough to cover a wide latitude, laying down specific duties or actions concerning any member of the legal profession is equally important. Finally, Canon 1 lacks provisions that outline specific positive duties that reinforce the role of a lawyer in society. Although Canon 1 itself is a positive duty, the provisions that follow should be specific enough to closely resemble the tenor of its title.
In Section 2 of our paper, we challenge the level of guidance provided by Canon 1, in general and to recent events. In the title of Canon 1, the three roles of a lawyer in society are: first, to uphold the Constitution; second, to obey the laws of the land; and third, to promote respect for law and the legal processes. Despite such lofty ideals and high standards, the four subsections therein are wanting of substance. The first two provide prohibition in support of the second rule, and the last two provide a modicum of specificity for the third rule. What then does it mean for a lawyer to uphold the Constitution? Are they meant to uphold it only when the situation arises and duty calls? There are too many provisions in the Constitution to know which part of it a lawyer should play an active role in. Providing specific provisions under Canon 1 can help stamp out ambiguity and underscore vital duties of a lawyer. In many cases, requiring positive duties trumps mere spelling out of prohibitions. For example, in the recent elections, widespread disinformation and cyberbullying pervaded social media. If the premise is that society has entrusted the dispensation of justice to the legal profession, can lawyers be called upon to avert such injustices? It is technically not a crime to do nothing. But given the high standard placed upon lawyers, shouldn't they use their knowledge of the law and of truth in order to suppress such evil? A lawyer must act to prevent the further spread of a wrong, even when inaction in certain cases is not contrary to law or good morals. These are only a few examples of questions that can arise in the minds of not just lawyers, but also the people that encounter them. How much should laymen expect from lawyers during trying times, such as the unprecedented crisis we faced during the elections? Could we hold them accountable? Canon 1 remains silent.
We have determined the shortfalls of Canon 1 and the disconnect between its title and the provision it contains in this paper. In order for the said canon of the Code of Professional Responsibility to remain relevant to its purpose of establishing a lawyer's role in society, we propose this additional provision. Rule 1.05. Lawyers shall not use their influence, authority, and legal skill to propagate disinformation within society. Instead, lawyers shall dispel the proliferation of false information and be exemplars of truth that is grounded upon historical facts, verified information, and evidence. Aside from the aforementioned reasons surrounding the shortfalls of Canon 1, we ground the proposition of this additional provision on a number of reasons. The rationale behind Rule 1.05. First, the Philippines had been ranked globally in May 2022 as having the highest proportion of internet users who follow influencers on social media, a potent breeding ground for the spread of disinformation. Rule 1.05 aptly addresses this information under Canon 1, laying down guiding principles for lawyers on how they should actively participate in correcting this information. Lawyers are oftentimes recognized as public intellectuals and leaders in their own respect and should therefore be vested with civic obligations that transcend the confines of the legal system and are constructive to society at large. Lastly, what makes Rule 1.05 important is that it expressly prohibits acts that constitute disinformation while proceeding to direct in unambiguous terms which positive acts lawyers should do to help arrest or mitigate disinformation. All these requirements that have been mentioned fit squarely within the province of good lawyers.
The limitation of disinformation. In the proposed Rule 1.05, there is information being contemplated pertains to any of the following. 1. It amounts to material distortion of facts resulting from actual malice. 2. It takes the form of coordinated inauthentic behavior or malicious internet trolling. Or 3. It is resorted to by a lawyer who is a public officer or employee and uses this information in connection with the performance of his official duties. First, it must be emphasized that the scope of this information here specifically refers to those done to deliberately deceive, which sets it apart from misinformation where ill intent is absent. This information must also result to material distortion of facts, and this may take in the form of historical revisionism. Thus, when a lawyer uses his influence, authority, and legal skill to play an active role in the strategic alteration of collective memory, Rule 1.05 will apply. Second, the rule applies when a lawyer participates in coordinated inauthentic behavior or malicious internet trolling. Under this delimitation, this requisite must be present. 1. He is in conspiracy with a group of trolls or participated as a troll. 2. He uses influence, authority, and legal skill in the act of trolling. 3. Trolling is done to manipulate the perception of others regarding material facts. And 4. There must be actual malice. Lastly, the rule applies to a lawyer who is a public officer or employee when the subject of this information is connected with the performance of his official duties, and by the virtue of his office, he has access to documents and other materials that will determine the falsity and truthfulness of those informations.
What are the expectations from the proposed Rule 1.05? It is first important to note that the legal profession is imbued with public interest. However, Canon 1 fails to execute its purpose because its broad character exposes it to a multitude of interpretations, failing to hold lawyers to the highest moral standards. With the inception of Rule 1.05, it is expected that other professions will follow suit and that faith of the public to the legal profession as defenders of public interest and the rule of law will be restored. The proposed Rule 1.05 will also recognize the need to battle disinformation, developing responsible digital citizenship, particularly amongst members of the legal profession. We believe that lawyers should be at the least of the people to purvey false information. Despite the possible evolution of technology, we believe that the culture that will emanate from the implementation of the proposed Rule 1.05 will enhance the legal profession and its role in society. In effect, this will also strengthen the fact that the right of freedom of expression provided in the Bill of Rights also comes with moral responsibility. Responsible handling of information will lead to a culture wherein facts prevail, an ideal world that members of the legal profession should continue to strive for.
To sum it up, Canon 1 of the CPR falls short in defining in clear and adequate language which responsibilities exactly a lawyer should act upon to benefit society. It merely proscribes those acts which are injurious to society without fostering positive action. So, the proposed Rule 1.05 is a remedy to ambiguity. Although it only covers this information, we're of the impression that it'll create a solid base for crafting more specific provisions that highlight other important social issues that the lawyers of today can positively contribute in. We propose all these with the view that the code should not be seen as a static rule, but a living, breathing organism that adapts to the tide of time. Thank you.
Thank you from the class of Professor Banyes. Our next group, uh, also from the class of Professor Banyes. Let's welcome Ms. Boado, Ms. Espiritu, Ms. Pasqua, and Ms. Sukor on political and non-mechanistic, an investigative assessment on the selective applicability of the Lawyers Code of Professional Responsibility. Presentation, please. Comms, there's no sound from the presentation. Can we have the third group again? Please.
Good afternoon, everyone. We will be discussing
Thank
our
you.
paper entitled Political and Non-Mechanistic, an investigative assessment on the selective applicability of the Lawyer's Code of Professional Responsibility. In this assessment, our team investigated the recent events that showcase the application of the Lawyer's Code of Professional Responsibility. First in our discussion would be the instant administrative matter and the landmark case of Republic versus Sereno, wherein the former Chief Justice was ousted through a quo warranto proceeding. The offshoot matter was based mainly on her violation of Canons 11 and 13 of the said code. With this court proceeding and decision in mind, we dive deep into the behaviors of prominent legal professionals for the past few years, namely Attorney Larry Gadon, Vice President-elect Sara Duterte, Attorney Harry Roque, and Attorney Sal Panelo, and then compare the stringency of the code as implemented in the case of then Senator Laila De Lima. We dissect the seemingly selective applicability of the Code of Professional Responsibility and ponder on the possible improvements for the betterment of the code and the profession in its entirety.
To formally open our discussion, we first go to Republic versus Sereno. On May 11, 2018, then Chief Justice Maria Lourdes Sereno was removed from her position as Chief Magistrate of the highest court through a quo warranto proceeding and not impeachment, where the Supreme Court and Bank voted 8-6 against her for her failure to submit her salin. After violating the sub judice rule, an offshoot administrative matter was instituted, and she was found guilty of violating Canons 11 and 13. While she was only reprimanded, the court cited as one of the merits of the case that it, as the disciplining authority of the legal field, ensures that each lawyer follows the path demanded by the virtues of the profession, and thus members of the court must be held to a higher standard of competence, integrity, and independence. Similarly, Justice Leonen, in his dissenting opinion, said that the Chief Justice must exemplify the highest standard of leadership and must refrain from activities that will tend to cause unwarranted attacks against the court. While this is very respectable, somehow this goes against what was discussed in Apolinar Petilo versus Maramot, decided in the same year in early 2018. And this is what was stated there. We can see then that the responsibility to abide by what is stipulated in the Code of Professional Responsibility is shared by every lawyer without making any distinctions on seniority or position. Each canon and rule begins with the phrase "a lawyer shall," meaning that compliance with the tenets of the code is a basic expectation of any lawyer, regardless of field or rank, and that compliance of the code is as foundational as taking the oath itself. Despite the court's proactive action in determining the non-compliance of one of its members, any inaction or inability to hold other officers of the court to account for violating the code could constitute selective applicability, or unequal application of a law that necessarily should cover all practitioners and not just members of the court. And despite the commonness of placing higher standards on particular public officers, and given that the code is a foundational aspect of the legal profession, the improper application of the law may cast doubt on the credibility of the entire legal profession. First, it might give the impression that these rules are only truly applicable at the given level of office or standing in the profession, and if the court is constrained to exert swift and decisive action, lawyers whose practices are much closer to the people could be left with limited legal mechanisms to ensure their compliance with the tenets of the code. Lastly, any indication of a lack of teeth, to borrow from the Apolinar Petilo case, could only be met with further complacency and inability to reform. To illustrate, we will be presenting a few cases where duly registered lawyers may have failed to properly comply with the code, but were not given the same weight or urgency by the Supreme Court.
First in the list is a man known for his involvement in numerous high-profile cases and controversial conduct, Attorney Lorenzo Larry Gadon. Attorney Gadon is known for filing the above-mentioned impeachment complaint against Chief Justice Sereno. He was also among the counsels of former President Gloria Macapagal Arroyo. In 2018, at least 4 disbarment cases were filed against Gadon for cursing and flashing his middle finger during a Baguio City protest related to Sereno's case. He called the supporters of Sereno, and I quote, "mga bobo," and raised his middle finger at them. This is a clear violation of Rule 7.03 of the CPR. Now, 2 other disbarment cases were filed against Gadon in 2018. The first disbarment case was due to his vow made in a senatorial interview to attack and kill all members of the Moro Islamic Liberation Front, including their wives and children. And the second one was filed by lawyer Wilfredo Garrido Jr. over his alleged false statements against ousted Supreme Court Chief Justice Sereno. In 2019, the Supreme Court imposed a 3-month suspension on Gadon for using offensive language towards a doctor, citing a violation of the CPR. In a ruling dated June 26, 2019, found in Mendoza versus Gadon, the High Tribunal found Gadon guilty of breaching his oath as a lawyer and of culpable violation of Code of Ethics of the legal profession, specifically violating Canon 1, Canon 8, and Rule 8.01 of the CPR. In 2021, during a radio guesting, a support group of people living with HIV and AIDS filed a disbarment case against Gadon after he claimed on air that the late President Benigno Aquino III had HIV. And in January 4, 2022, the Supreme Court ordered the preventive suspension of Gadon in connection with his viral video uttering profanities against journalist Raisa Robles. Another notorious disbarment case is that of Vice President-elect Sara Duterte. On July 1, 2011, a TV crew caught the local chief chief executive in the act of assaulting a sheriff who refused her request to delay demolition in a Davao slum area. Following the violent incident, 2 disbarment cases were filed against Duterte. Fernando Perito filed the first disbarment case against Duterte following the clash, which occurred during the execution of a court-issued demolition of informal settlements in Barangay Soliman, Davao City. The Sheriff's Confederation of the Philippines, Incorporated, or SCOFIL, which perceived the incident as, I quote, an affront against all court sheriffs and expressed that they cannot tolerate the mockery of the court's writs and processes, filed a case for direct assault and grave misconduct against Duterte. However, the Office of the Ombudsman dismissed the case and merely reprimanded Duterte. SCOFIL thereafter filed the second disbarment case. Duterte was accused of violating Canon 1, Rules 1.01 and 1.02, and Canon 11 of the Code of Professional Responsibility. But it remains unknown as to when the Supreme Court will give a final verdict on the long overdue disbarment cases of Duterte.
Take note of Canon 6 and Rule 602 of the Code. Among other prominent lawyers in the government service who appear to have committed behavior unbecoming of a lawyer is Harry Roque. Roque alleged that Kabayan Representative Salo, as a lawmaker, received bribes and used that money to build a house for his sister. Case was dismissed by the Integrated Bar of the Philippines in December 2019 and affirmed by the Supreme Court in 2021. Salo and Roque continued to lambast each other in a heated verbal and legal battle, which began when Salo publicly called for Roque's ouster from both the party and from Congress due to conduct inimical to the image and interests of the party, referring to the questions asked by Roque about Senator De Lima's personal life during a House hearing. Salvador Panelo is yet another lawyer who demonstrated questionable conduct. In 2019, Panelo implicated several members of media, political personalities, and athletes for allegedly being involved in a conspiracy to destabilize the administration. Instead of apologizing for spreading misinformation, Panelo blamed the media for the alleged wrong analysis. As the chief presidential legal counsel of President Duterte, or the top lawyer in the executive branch, there should also arguably be a higher degree of accountability demanded of him, following the logic of what has been stated in the matter against Chief Justice Serrano. Furthermore, through his position, Panelo would have had influence over state policy and the manner in which either the DOJ or any state instrument such as the NTF-ELCA carried out any formal investigation, or the way the state would prosecute its case and therefore affect the dispensation of justice. In contrast to the preceding examples of prominent lawyers facing multiple disbarment cases is former Senator Leila de Lima. The human rights lawyer was undoubtedly a fierce opposition to the Duterte administration, having launched an investigation in the war on drugs. She further argued that the drug war is a tool to silence the administration's political dissenters and adversaries. In 2016, the VACC, together with ex-officials of the NBI, filed a disbarment complaint against de Lima for gross immorality due to her extramarital affair and alleged tolerance of the illegal drug trade inside the New Bilibid prison in order to obtain support and win the 2016 elections. A similar complaint was filed by Prieto that year. On January 10, 2017, in what appears to be a relatively quicker action compared to other prominent lawyers facing disbarment cases, the Supreme Court directed de Lima to submit an answer to Prieto's complaint affidavit. One cannot exclude the possibility that the disbarment cases against her were politically motivated. Granted, the Supreme Court has yet to give a final verdict based on the merits of the cases. The question that could be posed is how the judiciary can ensure that the code is not being weaponized or used as a political tool to silence opposition, grievance, or dissent. Similarly, while the merits of the dismissal or junking of other complaints against the earlier mentioned lawyers may be procedural or technical in nature and the wisdom of the High Court is not questioned, it may be worth asking why these controversial lawyers remain steadfast and brazen in the way they conduct themselves. Is this a product of the seemingly inconsistent application of the code, wherein some lawyers get a pass while some have been disciplinarily dealt with for lesser instances of malfeasance, misfeasance, or nonfeasance?
Now, to conclude, the ubiquity of legal practitioners in both the public and private spheres necessitates a well-oiled mechanism where the integrity and moral uprightness of the institution is preserved and enhanced among all its practitioners. Despite the Supreme Court's position at the apex of the nation's legal system, the actions of practitioners from within the judiciary's co-equal branches may indeed be interpreted as glaring violations of the code, yet they were not held to the same degree of professional conduct expected of any lawyer. Should the legal profession fail to uphold its standards equally among all its members, the notion that the integrity of the judiciary is questionable would be hard to deny. Such inaction would also jeopardize the standing of all fields and institutions, such as the legislature, private businesses, local governments, or institutions of legal education.
To continue, in AM number 180601SC, the court has emphasized the high sense of morality, honesty, and fair dealing expected and required of members of the bar and bench. A lawyer may not divide himself as an attorney at one time and a mere citizen at another. Furthermore, the court eloquently said that any departure from the path which a lawyer must follow, as demanded by the virtues of his profession, shall not be tolerated by this court as the disciplining authority. For there is perhaps no profession after that of the sacred ministry in which a high-toned morality is more imperative than that of the law. Among all classes and professions, it is the lawyer who is most sacredly bound to uphold the laws, as he is its sworn servant. As the court aptly said, practicing law is a privilege burdened with conditions, requiring strict adherence to the rigid standards of mental fitness and rigor, as well as maintenance and fidelity of the highest degree of morality and faithful compliance with the rules of the legal profession. As such, the Supreme Court, as the constitutional guardian of the legal profession, possesses the ultimate disciplinary power over all attorneys, and this authority to discipline its members is not only a right, but a bounden duty as well. As the final arbiter in disciplining authority, and of course in a bid to assertively show the power of the judiciary, the High Tribunal should not exercise restraint or hesitate to suspend or disbar erring lawyers in the executive and legislative branches, as they occupy positions to serve the public. More so, such lawyers are expected to be embodiments of the Code of Professional Responsibility at all times. And it is only by the Supreme Court's proper regulation of the practice of the law that our judiciary can be confident enough to present itself with high standards and undeniable fairness. Now, as aspiring lawyers of the new generation, the Code of Professional Responsibility must not only be upheld, especially upon witnessing the recent behaviors of the professionals who were once hopeful law students as well. In our studies, we are taught that as important as it is to follow the law and its rules, questioning the equality and validity of the same is just as vital in promoting a fair justice system. Tomorrow's lawyers, above everything else that the code requires, must always keep a questioning mind on the laws they are tasked to be keepers of. Tomorrow's lawyers, above all, must sustain an eager desire for a system that does not discriminate and act upon arbitrary decisions. For the honor in practicing the legal profession does not lie on the knowledge or mere title it brings. The honor in practicing the legal profession is in the confidence that the institution and structure we work in protects the people it was designed for and provides equity-driven justice. That is all for us. Thank you and God bless.
Okay. Thank you. Third group. Our next group will be from the class of Professor Banyas again, comprised of Ms. Cuenca, Ms. Flores, Ms. Gomez, Mr. Ibay, and Mr. Pineda on From Start to Finish, Commencement of Lawyer-Client Relationships in Light of Social Media and Pro Bono Cases.
Hello, hello. Testing, testing. Okay. Magandang hapon sa ating lahat. I'm Robert Ibay, here to represent Cuenca, Flores, Gomez, myself, and Ms. Pineda. Shout out to our professor, Prof. Banyes. We're probably here to do a live presentation in light of so many recorded vids. So hopefully we're all present and I can dispart my group's research so far with regards to the commencement of lawyer-client relations. So when does it begin? When does it end? We've had a lot of lovely topics so far. Yung ibang video may soundtrack pa nga eh. But yung topic namin functions as a kind of like a prequel movie, no? X-Men Origins or that one cringe Joker movie, getting to the root, to the start of the obligation per se. Because how can we apply ethical principles when we can't even agree on the beginnings? So Chapter 4, specifically Canons 14 until 22, syempre, we have the Code of Professional Responsibility, di ba? Now, Canons 14 until 22 talk about the lawyer and the client, how these rules govern how a lawyer must maintain the relationship. But this specific canons does not explicitly delineate when the lawyer-client relationship commences. Based on jurisprudence, so far we can determine there's an agreement and there are legal fees. Now, that gives rise to the lawyer-client relationship. The jurisprudence cases we got here are from Santos versus Chumamil, 2016, Spouses Vargas versus Orino, 2019, wherein a lawyer-client relationship commences when a lawyer signifies his agreement to handle a client's case. And of course, as per legal fees, acceptance of money from a client establishes an attorney-client relationship and gives rise to the duty of fidelity to the client's cause. But of course, enough bombarding you with text, no? Let's come up with a visual example. So this one lawyer is being held up by two criminals because he knows too much about the criminal trade. They're gonna shoot him to get rid of him. But the guy says, no, attorney-client privilege. Everything that happens between us is strictly confidential, under threat of disbarment. Just put $1 in my pocket, and we're good. We have an attorney-client relationship. So this guy, instead of dying, no, he comes up with a couple of dollars pa and two new clients. Now, this is just a fictitious visual, but it's to hammer down the point that the lawyer-client relationship is special and protected. In fact, under the Data Privacy Act, any information shared between them is considered a protected relationship, also based on the list of rules of court. Now, this relationship isn't like, I don't know, breaking up with an ex, or, you hanging out with friends. No, no. This relationship is special because it gives rise to responsibilities and duties. Now, back then, of course, barristers with their white wigs and their long black robes, you can just shake on it. But things get a little blurry, especially with the new digital era. As laws catch up and technology catches up in itself, diba? A lot of problems become gray instead of black and white per se. I mean, the power of technology has brought me here speaking live to you. And in a sense, you're all there, seated, relaxed, listening to me right now. Now, the issue here arises that the fact is, in the Philippines, we are top consumers of internet and social media. In fact, this data I got when I was still working in government back in 2017, but you can pull it off Google 2021, 2022. We're still there. So the issues here are, do online legal services still fall under Canon 2? Should legal services be publicly available online? Does an attorney-client relationship arise from live streams? When in fact, Canon 2 states, diba, a lawyer shall make his legal services available in an efficient and convenient manner compatible with independence, integrity, and effectiveness of the profession. Technology is why we can speak here today. Technology is why, despite COVID confinements, we're still here talking to one another. So what's the problem with technology? We all know the CPR was prevalent well before the internet. Now, legal assistance, if you can search online, there's TikTok videos, Facebook videos, YouTube. Now, the problem here is when a lawyer hosts a webinar, for example, diba? And he accepts a call from one of his viewers. So he's giving non-specific legal advice. And then suddenly there's this viewer who goes, but attorney, you see my very specific relative has this very specific problem, and I'm saying this very specific detail. Now, if the attorney, of course, gives a very specific answer to that, a very specific legal answer to a very specific legal request, should he be held responsible? Kasi diba, there are responsibilities that arise. This is a very special relationship. Should the person act? Was there a certain sense of responsibility at play? So when we were talking earlier about acceptance and legal fees, where's the acceptance of a client's case here? It sounds too vague. With regards to legal fees naman, of course, we all know the 1987 Constitution says free access to the courts and adequate legal assistance not to be denied to any person by reason of poverty. We all have a right to counsel. In fact, the Code of Professional Responsibility even says a lawyer shall not refuse his services to the needy. So earlier we were talking about social media. Now we're talking about pro bono. What constitutes legal assistance in relation to the lawyer-client relation if there's no money involved? Back then sa high school ko, there was this funny saying na eto piso, hanap kang kausap. What if walang piso, walang dollar to put in my pocket? Is there a relationship with regards to that? Now, there is nothing that explicitly states there is a start of or a commencement of a lawyer-client relationship, which thus brings us further to what my group did. So we went over Canon 2, Canon 14, then we went over some of the other relevant provisions, Canon 15, Rules of Evidence. I won't have to read this to you because I only have about 10 minutes, no? But the main thing we plan to do, or the thing we proposed with this was, we combined Canons 2 and 14, namely proposed Canon 14, a lawyer shall be bound by the rules of the profession upon the commencement of, and with a view to the lawyer-client relationship. So this should be congruent with the rules of evidence I showed earlier. As well, we will also consolidate a couple of commencement rules, more of addition rather than revision. Because having worked in IT, damage control is something we have to find out. Diba? In fact, laws are very good at this. So in fleshing this out even further, we said, a lawyer-client relationship begins the moment a lawyer willingly provides a legal service in response to a client's request for legal assistance. So, well, we'll get to the money and the agreement in a bit, no? But this is to be reasonably ascertained by the courts. No need to read the rest of the fluff. We got this mostly from to also resolve pakisuyo cases, no, where there's a family lawyer and then a tito lawyer, pwede ba i-handle to? And what do I do with this? So, and then syempre sasagot si, ano. In this case of Burby versus Magulta, it explained, and this is older by the way, 2002, compared to the earlier 2012 ones I showed you. This one said that a lawyer-client relationship was established from the very first moment the complainant asked the respondent for legal advice. So it's not essential that the client employed the attorney as a retainer, not essential that there was a promise, but the very first moment legal advice was offered. Because what separates a layman from a lawyer? The layman only knows legal knowledge, but the lawyer knows the ramifications of the application of this legal knowledge. So in this proposed rule, we thus said na willingly provide a legal service. Because syempre, we don't want the lovely men and women of our judiciary, no, to have a gun pointed to their head providing legal services under extortion. So another proposed rule to add to that, a lawyer's acceptance of money, this is the explicit and the implicit. So this is how we incorporate the legal fees and the agreement into account. An explicit way of establishing an attorney-client relationship would be the acceptance of money, and then implicit lawyer subsequent actions. So this should cover some of the issues we talked about, namely with regards to social media, with regards to pro bono, kasi through this, you can cover now certain facts that weren't covered previously. And through codification, we can thus further cement what the borderline thing is with regards to the lawyer-client relationship. So we also further expand, express and implied in the other subsequent provisions under 14.06. Next would be 14.07. A lawyer should not obscure the commencement of any lawyer-client relationship. In a way, they shouldn't parang avoid or shirk responsibility per se. So innocent until proven guilty, here we try to apply something similar, immediately presumed as providing a legal service. And to the best of his ability, he must inform those he is engaged with the nature of the legal relationship. Kasi in the same sense that when a person approaches a doctor, di ba? The doctor says the responsibilities, this is the advice I'm giving you, other doctor might advise otherwise, but here, this is for the protection of both the client and the lawyer. Now, another one here would be obligated to inform potential clients that giving client-specific legal services signifies the commencement of a lawyer-client relationship. All this seems like a bit too much, yes. Pero in a way, when addressing that one issue na when a viewer is online, saying specific details, I went over the Data Privacy Act, diba? These are information that's privileged information that you can't just shatter lawyer-client privilege in front of so many people. So the lawyer can thus protect a potential client and himself as well when dealing with such information. So a lot of this might seem restrictive. I go back to that one quote when we were in regulatory, when we were regulating data privacy. Laws too gentle are seldom obeyed, too severe seldom executed. While we do understand the advantages of not codifying it, we are of the opinion, me and my group mates, that codification along with the proposed revisions and codes might actually benefit in the sense of protecting clients and the attorneys, while also not siyempre, suffocating our future members of the court and the current members of the court. So I believe that's it. Thank you very much. That's my group.
Thank you, Group 4. Our next group will be from the class of Professor Bonoan. Is this Mr. Bakar, Ms. Estigoy, Ms. Pakana, Ms. Dazo, and Mr. Digay on liberalization in the advertising of legal services. Presentation, please.
Good day, everyone. I am Robert Digay. Our topic is the liberalization in the advertising of legal services. In the Philippine jurisdiction, the law profession is one endowed with public interest, where the primary consideration is public service. This is vital to the keeping of an orderly society. We are of the opinion that the Filipino is better off well informed in the services offered by lawyers available to them. According to Hazard, Pierce, and Stempel, in their paper A Market Analysis of Legal Services, debates sometimes fail to recognize that legal services are a market commodity for the public. Proponents against advertising would state that lawyer reputation is the only reliable guide. However, supporters argue that advertising would allow more lawyers to enter the market, and additional information about the lawyers themselves will make their way to the public. Thus, the more reputable lawyers will eventually get more clients, and the public, in turn, will be able to make more informed decisions. Hazard and his co-authors posit that permitting broader use of advertising can lead to improvements in the function of legal services without threatening the ideal that justice cannot be sold. However, there must still be limitations, and these will be discussed later by my co-presenters. In the advent of the internet, the old ways of advertising have become outdated, as a single free post on Facebook can reach far more people than a mere calling card. While the expected conduct of a lawyer has remained the same throughout the years, it must also be expected that the profession learns to adapt to modernity. Today, we will discuss Rule 2.03, along with our recommendations, analysis, and perhaps possible limitations. To discuss the revision, together with various jurisprudence, may I present Mr. Rafael Bakar. Thank you.
Thank you for that wonderful introduction, Robert. So as we can see here, Rule 2.03 of the Code of Professional Responsibility prohibits all lawyers from conducting any acts considered to be solicitation of legal business. Included in this prohibition is the promotion of services through any form of advertising, including print, digital.
One of his own choice. Now, as the right is extended to situations where an individual is merely invited for questioning, there's all the more need to easily know and easily avail of legal remedies. And from all these, we see how accessing legal services is undoubtedly an essential step towards attaining justice. And this highlights the importance for a person to know, one, what legal services they need, what actually are available, and where to find them. Knowledge on these information should be easily accessible, and channels where such information is available must not be as limited. Next slide, please. Such problem is present here in the Philippines, as also mentioned by the earlier groups. And to reiterate, studies have also shown that access to lawyer in the Philippines remains difficult, where according to a survey by the World Justice Project back in 2018, 20% of Filipinos were able to access legal help. And out of the 20%, most of them seek from family and friends and not from legal institutions. This shows and this manifests the gap between people and the justice system, in which, in part, this is due to the lack of awareness of people of the legal services that are provided and services that which they could actually avail. Now, the expansion of platforms to which lawyers may communicate their services, their profession, is therefore timely and at the same time inevitable, especially with the internet. Next slide. Finally, the continuous limitation of legal advertisement and thus the access to information on legal services may result in people to resorting other forms of justices, such as radio and mainstream television programs, or informal internet groups giving quote-unquote legal advice, as these are easily accessible to the general public. Next slide. With the arguments provided, we recommend a review of Canon 3, which will allow a more liberalized yet still regulated legal advertising, as long as it gives due consideration to the legal profession and its practices. To further discuss the group's recommendation, I now call on my group mate, Ms. Chrysler Billion.
Thank you, Jean. So next slide, please. A few years after the court's ruling in ULEP versus Legal Clinic, which effectively imposed a blanket prohibition on legal advertising in the Philippines, the use of technology has become more pervasive, which brought in new means of communication on one hand, but also new challenges to the regulation of advertising on the other. Next, advertising has transitioned from print media to broadcast media, which expanded target audiences, and now to the use of online platforms for industries to advertise their products and services. Online advertising is defined as the use of the internet as a medium to deliver marketing messages to an intended audience. So the legal profession is one of those who kept up with these rapidly changing trends in advertising. With the rise of the internet, Lawyers and law firms have created websites which provide information about them and effectively market their legal services. These websites contain information about the lawyers, their areas of practice, and other legal resources that are easily accessible to the public. Next, please. In some cases, websites directly offer legal services through online media that could easily be searched in just a click. So these websites and online platforms necessarily contain more information than those provided by law lists and professional cards, which, as mentioned earlier, are deemed by the court as exceptions to its blanket prescription on legal advertising. Applying the dictum expressio unius est exclusio alterius, online platforms are excluded from such exceptions and are therefore currently not considered as permissible forms of legal advertising. To adapt to these changing times, it is crucial now to review the court's rules on advertising, especially through online media. To do this, we recommend that the court promulgate a new rule to be known as Rule 3.05, which would allow a lawyer to advertise his or her legal services online. Although the court in ULEP ruled that legal advertising may deteriorate public opinion on the legal profession, such an argument sits differently now that we have a different understanding of the nature of advertising, especially with the rise of the internet. So why online legal advertising? Economic analyses have shown that online advertising, as compared with traditional means, substantially reduces costs for audience targeting. So this rebuts the notion that advertising puts in more overhead costs for lawyers and induces them to raise their attorneys' fees. Moreover, online platforms are accessible to anyone, which levels the playing field among lawyers to effectively put out their legal qualifications and services. So this is especially true in the Philippines, where most people have access to the internet. A survey released by Pulse Asia in October 2021 shows that 63% of Filipino adults use the internet, which justifies the need to include online media in the permissible forms of legal advertising. However, these same statistics highlights that while the rules on advertising must be loosened up, such liberalization should not be absolute and must remain subject to the ethical requirements for members of the bar. So online media is unlike any other modes of communication that have been previously known. While the internet enables its users to eliminate distances between them, it also allows these users to remain anonymous and therefore non-accountable. So to emphasize, websites are available to anyone at any time, and information posted therein are not always verified for their accuracy. So specifically for the legal profession, information posted in websites are not limited to just the basic information about the lawyers or the firms. Lawyers would want to establish a well-merited reputation and could publish potentially misleading qualifications and specializations. Moreover, websites may contain legal information such as Supreme Court decisions that provide general doctrines which readers may mistakenly apply to their specific legal problems. Hence, we emphasize that while the court should liberalize its rules on online advertising, it should be done only through proper representation of the lawyer's capacities and without making false or misleading statements. In summary, we propose that Rule 3.05 should be added to the Code of Professional Responsibility, which states that a lawyer may advertise his or her legal services online by proper representation of his or her capacities and without making false or misleading statements. Next, please. The internet has become the most weaponized technology that threatens justice and democracy in the country.
The Philippine law prohibits any form of advertisement and solicitation of legal services, which is subjected to a few exceptions. Solicitation that has the purpose to gain, either personally or through paid agents or brokers, makes it as a prohibited act as stated in Rule 2.03 of the Code of Professional Responsibility. And in the case of ULEP versus Legal Clinic, the Supreme Court held that the standards of the legal profession condemn the lawyer's advertisements of his talents. A lawyer cannot, without violating the ethics of his profession, advertise his talents, or skills in a manner similar to a merchant advertising his goods. Just like the other professions, the legal profession had been affected by the internet, and the lawyers and law firms saw this as a opportunity to further promote their legal services to other people through prominent social media platforms, or they may have created their own websites. And this paper is an analysis on the impact of the internet on the legal profession, and it's both timely and imperative.
So for this report, we must mark the difference between traditional and online advertising. Both forms can be measured in terms of scope, time, format, targeting ability, and regulations. However, online advertising virtually does away with the conventional constraints traditional advertisers deal with, and this warrants that online ads be classified differently. Now, for example, a company can get a TV ad to be played like every 5 hours for 30 seconds each. This ad will be played to whoever is watching that channel at that time, no more, no less. Only people where the channel airs can watch the ad, and the most the company can do is a creative video with no ways for the audience to interact. On the other hand, if the company chooses to do the ad on social media, it can decide to show it abroad, perhaps to countries with many OFWs. If the product's target market are women, then the company can tweak the settings to exclude other genders. And the ads can have hyperlinks and other buttons for audience interaction.
As the platforms for advertising change, the OLAV standard will not address most of the problems. Specifically for this study is the search engine marketing. So it is a strategy to improve the exposure of website on search engine result pages, mostly through paid advertisement. There are two methods that it provides. First is the pay-per-click at marketing, especially in Google Ads. Google uses keywords and cookies from the consumer to place advertisement created for them. However, to avail of this, all the advertisers must bid for the keyword so their website will be more recommended. A quick search on Google of law firm, law office will show top searches of lawyers and law firm with a small badge of ad in the corner. It is unethical for lawyers to use this because they must pay for publicity to attract clients. Second is the marketing strategy of search engine optimization. So SEO refers to the processing of optimizing web pages and content to improve search engine rankings. And this does not entirely need to be paid, unlike pay-per-click advertisement. And there are two types of it. First is the on-page SEO, which is the improvement of the elements and attributes within the website, such as the contents and HTML. However, there are functions to deceive the search engine, such as the use of meta tags and invisible inks. So meta tags are words and phrases that are incorporated into HTML code. For example, a website will have a meta tag of tax, litigation, or annulment in their HTML. However, if you search those keywords, you can also deceive the searcher by putting best tax litigation lawyer or best annulment lawyer in the HTML. Then there is also the use of invisible ink wherein you place the word with the same color as the background or homepage so that they are not visible. One can input keywords like the competitor name to create a deceitful promotion of their website if someone is searching their competitor's name. Both of it is clearly misleading representation in the development of their website and a violation of Canon 2.0 and 3.01. Hence, this should be addressed by the regulatory authority.
For off-page optimization, it primarily focuses on link creation and social media integration. The use of internet websites and pages or accounts for the ease of communication to the public should be allowed, as traditional means of advertising for the legal profession is now become obsolete with the emergence of the internet. People would rather opt to locate your Facebook profile than your business card. Currently, lawyers and law firms are now utilizing social medias as a networking platform to connect with fellow lawyers and prospective clients. But as for any other tools for marketing, this can be abused. The use of social media can also serve as an unsolicited marketing tool. Ads which are unscrupulously placed between posts, such as those used in Facebook and Instagram. These platforms offers a variety of ways to advertise for business through paid ads and or what is called sponsored posts. There are also those paid advertisement made through influencers to speak good of a product or service and to encourage viewers or followers to buy or avail them. Hence, there must be a guideline that cautions the lawyer not to overstate their credentials, nor permit endorsement or testimonials by their colleagues, friends, or clients that may likely exaggerate or make misleading claims in their websites or social media accounts. The use of any paid advertisements should also be prohibited because this may lead to the misconception that the legal profession is profit oriented. That unless a person has a means to pay for the legal representation, they are not given the same quality of professional advice as their rich counterparts. This is in addition to the fact that the layperson are ill equipped to understand the sophistry of law, that they may be led to believe that the lawyers who are advertising would give their money's worth, even though they don't. And there's hardly any use for paid advertisement as lawyers can be found by searching for the term lawyer in any platform. Thus, advertising to the general public, similar to those of ordinary business, is unnecessary.
The case of ULEP allowed publication in reputable printed law lists as an exception to the prohibition on advertising of legal services. And the Supreme Court does maintain an online law list containing the names of lawyers and their roll number. However, to further aid individuals in finding an appropriate lawyer in their location for their particular legal concern, it may also help to cite a lawyer's office address, contact numbers, branches of law practice, education, and other affiliations, as is provided in ULEP. Adding a filter button also helps in which the person in need of legal assistance can further filter the records based on a criteria. In this way, it is the Supreme Court that provides credibility to lawyers as well as easy accessibility to people in need of legal help, rather than resorting to unnecessary advertising. Following ULIP alone, websites are not expressly or even impliedly allowed by the CPR. In today's time, websites are a form of communication between lawyers and the public. Professional websites should be deemed as permissible advertising, provided that the same does not resort to any false, fraudulent, misleading, undignified, or self-laudatory statement on a lawyer's qualifications or legal services. The internet should be acknowledged in how it has made legal services and legal information fully accessible, and so the use of websites should be liberalized but supervised so as to prevent contributing to the disinformation online. Lastly, lawyers and law firms must adopt a strict policy against spamming and forbid the sending of unsolicited bulk emails or in any form of online communication. Spamming practices must also include multiple posting of ads of legal services in online groups, message boards, forums, and chat rooms, especially in those online spaces that do not explicitly permit ads or have users that do not consent to such receipt and transmission.
There are two major effects of the amendment on the legal profession. So first, misleading nature of the attorney advertising. It has been argued that through the advertisement of legal services, it may mislead the public since the practice of law involves catering to unique problems that require individualized solutions through which advertising will not be able to convey. However, people who seek legal advice or services will not normally solely rely on the advertisement, and they would eventually contact the lawyer concerned in person and actually get the complete information about the legal service being offered. The last effect is the difficulties in enforcing the rule. The claim is that oversight of regulated advertising can be burdensome due to the sheer number of purveyors of legal services. However, every lawyer that overreaches through advertising, there will be other lawyers that will be candid and honest. And lastly, it will be in the interest of the bar association, particularly the Integrated Bar of the Philippines, to assist in weeding out those lawyers who abuse their trust.
Overall, we are proposing ways for a lawyer to publicize his services while maintaining a sense of pride in the profession. For instance, we recommend allowing online accounts but prohibiting paid ads. Lawyers must remain dignified, but public service requires public awareness. Given today's technology, rules on advertising must adapt. We do not reject the spirit behind the rules against ads, but we only seek to calibrate them to meet the demands of society today. Thank you and have a nice day.
Thank you. Our next group, Miss Sikat, Miss Aronales, Miss Tolentino, Mr. Buan, and Miss Aguilar from class of Professor Lim Ong. The topic, revisiting canons on the prohibitions on advertisements in digital age. presentation, please.
Good afternoon, everyone. So today our group will be revisiting the existing canons on the prohibition on advertisements and will examine its applicability within a rapidly progressing digital age by comparing the circumstances behind the canons and how we adapted them in today's factual milieu while still retaining their spirit and intent. So at present, we have existing canons from both the Code of Professional Responsibility and the Canon of Professional Ethics that prohibit advertising of legal services, with a few exceptions. Time and again, the Supreme Court has reminded lawyers that the practice of law is a profession and not a business. Lawyers should not advertise their talents as merchants advertise their wares. To allow lawyers to advertise their talents or skills is to commercialize the practice of law, degrade the profession, and the public's estimation and impair its ability to efficiently render that high character of service to which every member of the bar is called. But looking at today's digital age, while it is true that lawyering is not a business and should not be treated as such, our group is of the opinion that advertising the services of a lawyer does not necessarily entail the same. Revisiting these canons will aid lawyers in reaching out to clients and at the same time help the public find lawyers when in need of them. In today's digital age, it is no surprise that a majority of the population has a digital presence. A quick search in Google or Facebook will show that these platforms are actually already being utilized by lawyers and law firms alike. However, since these canons do not specifically regulate these digital channels, there are no established guidelines on what kinds of posts are no longer in line with keeping the dignity of the legal profession as originally intended by the canons of professional responsibility. Thus, there's an even greater need to establish canons that will cover online presence in order to promote accountability amongst the lawyers of today and the generations to come. Our group aims to address these. To expound on the pertinent canons of our analysis and its history, I leave the floor to Ms. Bianel Arenales.
So in view of the growing importance of timely legal assistance, accessibility of legal services, the advent of social media, digital marketing, and how it impacts the legal profession in relation to the delivery of legal services, our group would like to revisit Canons 2 and 3 of the Code of Professional Responsibility. Now, as for Canon 2, it states that a lawyer shall make his legal services available in an efficient and convenient manner compatible with the independence, integrity, and effectiveness of the profession. We would like to focus specifically on Rule 2.03, which states that a lawyer shall not do or permit to be done any act designed primarily to solicit legal business. Now, our suggestion on this canon will be discussed later on. So, next slide, please. Okay, as for Canon 3, which states that a lawyer in making known his legal services shall use only true, honest, fair, dignified, and objective information or statement of facts. We would like to focus on 3 rules under this canon: Rule 3.01, Rule 3.02, and Rule 3.04. Likewise, the suggestions that we have that we would like to impose on this canon will be discussed later on. So on the next slide, please. So as for the background and history on these canons and the known prohibition on legal advertising. So we know that the anti-advertising rule was prevalent in the United States. So the prescription of legal advertising is rooted in the traditional notion that because the practice of law is a dignified profession, advertising legal services would necessarily erode such dignity. So this was the belief back then. Now, the drafters of the Code of Professional Responsibility drew inspiration from the American Bar Association's Code of Professional Ethics. Now, in drafting the proposed Code of Professional Responsibility, the rule on permissible advertising was adopted. In Canon 2 of this draft, lawyers were impliedly allowed to advertise, although they were prohibited to do or permit to be done any act or thing designed primarily to attract
or solicit illegal business. At the same time, the proposed code also prohibits lawyers from paying or giving anything of value to representatives of the mass media in anticipation of or in return for publicity to attract legal business. Now, we know that the legal profession is a form of public service. Then therefore advertising legal services would commercialize it. Now, to allow a lawyer to advertise his talent or skill is to commercialize the practice of law, lower the profession and public confidence, and lessen its ability to render efficiently that high character of service to which every member of the bar is called. Now, we know that this is a traditional and view that advertising tended to increase corruption, barratry, champerty, overreaching, fraud, and overcharging. Of course, this is no longer the case today, and thus we would like to suggest revisiting these two canons with regard to legal advertising. Now, we know that based on jurisprudence that the prohibition of legal advertising is not absolute. However, it remains vague. We believe that it is high time that legal advertising rules be revised to ensure a level playing field for all practicing members of the court. As for the relevant jurisprudence on this matter, I now pass the discussion to Ms. Christine Argenter.
In the case of ULEP versus Legal Clinic, the court held that the standards of the legal profession condemn the lawyer's advertisement of his talents. A lawyer cannot, without violating the ethics of his profession, advertise his talents or skills as in a manner similar to a merchant advertising his goods. In the case of Linsangan, the court held that to allow a lawyer to advertise his talent or skill is to commercialize the practice of law, degrade the profession in the public's estimation, and impair its ability to efficiently render that high character of service to which every member of the bar is called. It further states that a lawyer's best advertisement is a well-merited reputation for professional capacity and fidelity to trust based on his character and conduct. In the case of ULEP, the court also enumerated allowable advertisements such as ordinary simple professional card, publication in reputable law list with brief biographical and other informative data, and others. In the case of Can versus Imbilio, the court emphasized that the solicitation of legal business is not altogether prescribed. However, for solicitation to be proper, it must be compatible with the dignity of the legal profession. If it is made in a modest and decorous manner, it would bring no injury to the lawyer and to the bar. To discuss why the canons has to change and the suggestions and recommendations of the group, may I call on Mr. Gabuan.
Hello, thank you, Christine. And so I'm here to discuss why this needs to change. So first of all, we know that things are different now, and like the law, the canons of the code should also be adaptable to reflect the changes and needs we need during the present time. First, our group believes that we should give credence to the lawyer's freedom of speech, more specifically, their freedom of commercial speech, which would allow them to accurately represent themselves to potential clients in the digital space. Also remember in Tolentino versus Sangan, the Supreme Court said the practice of law is a profession, not a business. Lawyers should not advertise their talents as merchants, advertise their wares. Yes, we agree with that, but to a certain extent. But also, we think that the very existence of law firms runs contrary to the notion that legal profession is not a business. Because by business we mean like being busy, kaabalahan, occupation. So that's not a very thing we really agree with. And second, we think there's no shame or indignity when merchants advertise their products or their wares because for them it's still good and honest work. And we believe that giving more freedom to lawyers to advertise may even promote the public perception of the legal profession. We believe there's no shame in advertisement because at the end of the day, for a merchant, for example, it would be his products or his wares that would determine his success as a businessman or entrepreneur. And for the lawyer, it would still be his talent and his skill. It would eventually make his name and his mark in the legal profession. Now, this is very important for us because very important for us. Well, we're law students, but we believe this is important for new and young lawyers because they are more informed about the use of information technology. And this is something they could use in jumpstarting their careers. And we know that word of mouth is one of the most common way for lawyers and law firms to make a name for themselves. But this only helps big and long established lawyers and law firms. So what do young lawyers have? They don't have anything. They have what they have is their knowledge of information technology. And we believe that letting young lawyers advertise through the digital space, it would help them reach clients. At the same time, it will help the general public in finding lawyers when they are in need of them. And we know that everyday people could not afford big time lawyers, big time law firms, and they would rather prefer to contract the services of lawyers of modest reputation. In this way, this would create more work for young lawyers, more work for them, more experience, and in the future, which would help them to become reputable lawyers in the future. And this would create a more competitive space for young lawyers because we have if there's more competition, there's more skill that will come out of it. So what are suggestions for this? So first we have as mentioned by my colleagues earlier, we have rule oh, I think our slide is not yet okay. Can you go to the next slide for this one? Okay, so as mentioned by my colleague earlier, we have rule 2.03 of the code of professional responsibility, which says that a lawyer shall not do or permit to be done any act designed primarily to solicit legal business. So we are going to emphasize here the term of business, and we have shown earlier that the practice of law is not a business. So what would we suggest? We would suggest an addendum to this provision by adding further, in making his legal services known, a lawyer shall do or permit to be done only acts that are compatible with the integrity of the legal profession. Next, we have Canon 3, which states that a lawyer, in making known his legal services, shall use only true, honest, fair, dignified, and objective information or statement of facts. So we can see here that this provision no longer prohibits advertising per se, because as long as it's true, honest, fair, dignified, and objective. So we suggest that we should have a better understanding or a new definition of what is dignified, especially with the use of social media nowadays. And lastly, I think we should go back to the earlier slide, Ms. Aguilar, this one. We should have clear and defined guidelines on advertising for lawyers and law firms in the digital space. And these guidelines should be flexible enough to tie in with social media platforms because they also have their own rapidly changing rules when it comes to acceptable advertising. And we know that the culture of the digital space of social media changes very fast, changes every day. What is stand yesterday can be canceled tomorrow. So these guidelines should be flexible enough. And finally, we should really have a better understanding of what should be prohibited advertisements when it comes to social media for the legal profession. And to conclude our report, may I call on Ms. Vea Sikat.
Thank you, Mr. Buwan. So to conclude, our group ponders that it is high time we adapt and incorporate changes made necessary by today's digital age into the canons of professional responsibility. The technological and social advances we made were beyond contemplation of the original canons, rendering them insufficient to properly regulate the online mode of advertisements. The practice of law is a profession and not a business, yet we are faced with the reality that a quick search online would reveal the top firms on the front page. And yes, while the best form of advertisement is a well merited reputation, we also cannot discount that there may be lawyers who are competent yet unable to reach a wider base of clients unless they join a well known firm. At the same time, there are clients who need legal representation but may not be able to contact services or contract services from the top firms. Thus, it would serve the best interests of the legal profession and the public if lawyers are able to expand their reach using a broader platform like social media, subject, of course, to regulations in keeping with the dignity of the legal profession. Therefore, we suggest to amend Canons 2 and 3 by including digital platforms and the regulation of these platforms. A liberalization of the prohibition against advertisement, if properly implemented and complied with, can actually help in making legal services more available, more accessible, and more progressive. Thank you for listening and have a great day.
Thank you. Proceed to the next group. And on Canon 4, Miss Alcoreza, Miss De Guzman, Mr. Gancayco, Miss Rojas, and Miss Solis. Notarization meta, the move to a remote online notarization in the Philippines from the class of Professor Banyas. Presentation, please.
Good afternoon. My name is Rafael Gancayco, and on behalf of my group mates, Ms. Kayla Alcoreza, Ms. Diana de Guzman, and Ms. Casey Solis, me and Ms. Angeli Rojas will be presenting to you our presentation, the notarization meta, the move to remote online notarization in the Philippines. Our presentation is built on Canon 4 of the Code of Professional Responsibility, which states that a lawyer shall participate in the development of the legal system by initiating or supporting efforts in the law reform and in the improvement of the administration of justice. What we would like to reform or improve upon is the current notarial system in the Philippines. Modern technology has advanced very far since the last passing of the rules, and other jurisdictions use similar systems, and this shows that it is a mature technology. With the prevalent cell phone usage in the Philippines, the move to either adopt or move to a totally electronic notarization system is prime for us. Electronic notary has the benefits, especially for simple affidavits, like affidavits of loss or scholarship applications. This is because an efficient system would remove a lot of the unnecessary hurdles and provide a social and legal benefit. Social in the sense that people would no longer need to go out of their way to find a notary, and especially in the case of simple affidavits, could have their documents very easily notarized. And legal in the sense that if the documents could easily be viewed and verified online, as long as that person has the permission to do so, it would reduce the amount of hoops that a lawyer would need to jump through in order to verify the authenticity of a notarized document. The first step that would need to be taken in order to move to a totally electronic notarization system would be the move towards an electronic notarial database. That is because the current database system in the Philippines is outdated, inefficient, and messy. The current system puts the burden on the notary to keep records of the notarized documents. And in a lot of cases, these are handwritten since the documents must be submitted physically to clerks of court. Obviously, digital records would provide a more reliable archival and delivery function than physical records. And even a simple database with something as simple as a reference number is a huge upgrade over the current system. However, our group would like to propose a master database with a more sophisticated verification system that would provide a non-fungible character to these documents and utilize technologies such as blockchain, which would increase the social and legal benefits. So in order to move to that, we will build on the foundations set by two rulings of the Supreme Court. First, the 2004 notarial rules, and second, the 2020 interim rules on remote notarization of paper documents. Applying some changes to these rules to be used as building blocks for either this new or adjusted system, we would like to propose 5 changes. First, the expansion of scope. Second, the allowing of the use of e-signatures and electronic seals. Third, the removal of courier service option and the inclusion of an option to deliver the documents through electronic means. Fourth, the removal confirmation of the geolocation requirement. And fifth, on the revocation and administrative sanctions for notaries. The first topic that we would like to touch on is the expansion of the scope of notarial power. The current set of notarial rules make it clear that notaries are not allowed to operate outside of their locality. Now, this is interesting because lawyers, as long as you've passed the bar in the Philippines, are allowed to practice law anywhere in the Philippines, and we believe that this should apply to notaries as well. Also, in practice, this is already how notaries operate to a degree in the Philippines. These restrictions would work if you were in jurisdictions like the United States, where the practice of law is specific to each state and you would have to pass the bar in order to practice law in said state. But those things are not applicable here. And that's why we think that the opening up of the practice of notaries would be beneficial to the legal system. The second point on the expansion of the scope of the notary is that we would like to make the interim rules on remote notarization no longer interim. The specific qualifier for the IR that was passed is that the areas have to be under community quarantine. But we believe that the application of these rules, as well as further refining of our recommendations, will lead to a very, very sustainable electronic notarization system. And the third topic regarding the expansion of scope of the notarial power is regarding the application of e-signatures and electronic seals. It is not indicated in the current rules that electronic seals and electronic signatures are allowed. We believe that it should be in order to fully utilize remote or online notarization systems, including the one that we're proposing today. Going deeper into that topic, we would like to further discuss the allowance of the use of e-signatures and electronic seals. On the expansion of the use of e-signatures, currently the specific rules for notaries only speak of handwritten signatures. We believe that e-signatures should be specifically changed and allowed within the code. This provides benefits to both the principal and the notary. And we believe that any physical steps in a true electronic notary system would create an inefficiency that need not be created in the first place. This is because, especially again, for specific applications like simple affidavits, a true notary system and the application of e-signatures would create convenience and efficiency for both the notary as well as the principal. More importantly, between the two topics, especially as applied to a notary, would be the application and adoption of electronic seals. The base rules for the notarial seal provide a format with minimum requirements. However, we think that this leads to two problems. First, it makes the tampering of seals easier. Second, it makes each seal unverifiable as there is no universal format. Now, to solve these problems, we would like to recommend that the Notarial Commission issue a uniform seal to each new notary public, and that each of these seals be assigned an identification watermark, which would make it uneditable and less prone to being tampered and abused. A seal is more important, or is the more important factor in this thought exercise. The benefits of a standard seal allow for a database of seals that can be used for the physical and digital verification of documents as well as the seals themselves. Since it is uniform, seals can be issued to be used digitally in an instant, and physical manufacturing would essentially be automatic. Uniform seals would also lead to less abuse, as the differences and styles in the seal would be apparent from the start. This would include name, roll number, locality. And we also would like to point out that the rules should be adjusted to allow for the digital affixation of the seal to documents in order to fully utilize the specific and efficient notarization function. And moving into our third topic, I would like to pass the mic to my co-host, Ms. Angeli Rojas, to finish the presentation.
Our third proposal would be to remove the courier service option and to include an option to deliver the document through electronic means. The current rules on the notarial process implemented in the Philippines require the transmission of physical copies of the documents from one party to another. However, we believe that this system introduces more problems than it will solve. First, it creates a delay in the transmission of documents. Furthermore, the amount of people who has physical access to the document creates opportunities for tampering, loss, and damage to the document. Lastly, it creates an unnecessary economic burden on the principal who shoulders the cost of delivery, especially for those seeking notarial services for simple documents such as affidavits of loss or scholarship applications. Our proposal would be first, instead of delivering the document through a courier, the document can be sent to the notary public electronically. And in order to ensure the legitimacy of the document, it must bear an electronic seal. Second, instead of keeping the hard copy version of the document within the view of the principal, the notary public can share screen the document sent electronically for the principal to confirm if it was the right document and if the provisions therein are in order. The same rules are suggested for the confirmation of witnesses, as the digital method enables the users to yield better quality of photos and IDs for confirmation and further ease of availment of the service. Our fourth proposal would be to remove the confirmation of geolocation requirement. The current rules require the principal to confirm his or her location to the satisfaction of the notary public by showing his or her geolocation through an application with GPS capabilities or by showing the notary public identifiable landmarks or buildings within the vicinity. We propose that this provision be omitted. Given the proposed expanded scope of the rules, confirmation by the principal and witnesses of their respective locations by showing their geolocation through an application with GPS capabilities is no longer necessary. Furthermore, applications and software such as VPNs and other geolocation spoofing softwares are readily available to alter a person's actual location and can be used to tamper with the existing process to confirm the presence of the principal and the witness. To sum up our presentation, our proposal aims to provide for groundwork on the digitalization of the notarial system in the Philippines. With the fast progression of technology in our country, the implementation of an electronic notarial system could cure the outdated nature and inefficiencies of the existing system. Specifically, this could be made possible through 1, the expansion of scope in jurisdiction and signature. Number 2, the inclusion of e-signature and electronic seals. Number 3, the removal of the courier service option and instead providing for an option to deliver through electronic means. Number 4, the removal of the geolocation requirement. And number 5, the implementation of additional provisions on the revocation and administrative sanctions. The suggested rules provided are only recommendatory, but while it may be so, we believe that the move would be a step forward to a progressive direction that Canon 4 meant, to which we quote, "A lawyer shall participate in the development of the legal system by initiating or supporting efforts in law reform and in the improvement of the administration of justice." Jurisprudence provides that the notarial system is imbued with public interest, and so it is high time to adapt the digital world and change the notarial system for the better. That concludes our presentation on behalf of my team. Good afternoon and thank you.
Thank you. For our next group from the class of Professor Tadwico, we ask Ms. Abrea, Mr. De Castro, Mr. Lucagbo, Ms. Panga, and Ms. Tuburcio to present on upholding truth in the digital age, social media conduct, and the legal profession's duty to prevent disinformation. Presentation, please.
Polarize public opinion, influence politics, and undermine our democratic systems. Even more so when such misinformation or disinformation are perpetrated by individuals subject to the highest standard of ethical conduct. Thus, our proposal to uphold the truth in the digital age in relation to social media conduct and the legal profession's duty to prevent disinformation. The spread of misinformation, whether intentionally made or not, is directly related to our lack of mechanisms for accountability. Currently, the Code of Professional Responsibility does not categorically prohibit participation in the spread of false information. While it does hold lawyers accountable for using misleading information, these are limited in application due to the qualifications provided in the provision. The code only prevents the use of false information with regard to a lawyer's qualifications, choice of a firm name, or in connection with this application to the bar. Our current proposal seeks to address this gap by adding a provision categorically enjoining lawyers from participating in the spread of false information. Thus, we propose to add this provision. A lawyer shall not willingly or knowingly spread disinformation and refrain from contributing to misinformation on any matter in any form of media and for all public platforms.
The regulation for the use of media, especially social media for lawyers, is not at all a novel idea. In fact, the American Bar Association has issued ABA models that relate to its use. For example, under ABA Model Rule 7, lawyers are prohibited from making extrajudicial statements to the public that could prejudice a trial, and under ABA Model Rule 3.4a, lawyers are prohibited from unlawfully obstructing another party's access to evidence or unlawfully altering, destroying, or concealing a document with potential evidentiary value in reference to situations where a lawyer advises a client to delete or alter social media content that is relevant to a lawsuit. ABA Formal Opinion 18-480, which was released in March 2018, confirms that lawyers who use social media, blog, or engage in other public online commentaries are governed by the duty of confidentiality
of Model Rule of Professional Conduct 1.6, which provides that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. In this age of technology and social media, fake news is among the latest phenomena, highlighting the law's struggle to keep pace with technology. And in fact, the United Nations Special Rapporteur on the Promotion and Protection of the Right to Freedom of Opinion and Expression, David Kay, has called fake news a global topic of concern. Thus, it is time to reevaluate the Code of Professional Conduct, highlighting the pressing issues that surround the practice of law, including the proliferation of disinformation.
Our proposed additional provision holds a lawyer liable for willingly or knowingly spreading disinformation and for contributing to misinformation on any matter. A lawyer is thus punished if the information that he or she shares is proven to be false or incorrect based on verified information from reputable sources, whether such false or incorrect information is shared in the lawyer's personal or professional capacity. This provision covers information that the lawyer shares in various forms of media, which include print media, radio, television, and social media, as well as other public platforms, which may include public speaking engagements and online platforms such as personal blogs or websites. In essence, the proposed provision penalizes a lawyer for causing the proliferation of false or incorrect information and urges lawyers to observe utmost diligence and to be cautious with the influence that they hold when it comes to exercising their freedom of speech. By penalizing the spread of disinformation and misinformation, lawyers are reminded to verify their sources and to refrain from taking part in reckless and potentially unlawful speech, whether offline or online. The provision punishes conduct which adversely reflects on the lawyer's fitness to practice law, since participation in the spread of disinformation or misinformation indicates either a lack of character or a lack of discernment, respectively, on the part of the lawyer, and may likewise constitute scandalous behavior in certain instances, which can then bring discredit on the legal profession. Under this provision, the term disinformation shall cover false information deliberately spread in order to influence public opinion or obscure the truth, while misinformation shall cover incorrect or misleading information which is shared regardless of whether or not there is intent to receive. The term media covers means of communication that are designed to reach the mass of the people and shall include print media, television, radio, social media, and all other forms of communication that fall under the said definition. And the term public platform means any place or medium where the lawyer is provided an opportunity for expression, whether online or offline, that may be accessed by a defined group of people or by the general public. Online public platforms include, among others, websites, personal blogs, and online publications, while offline public platforms include conventions, rallies, and other public speaking engagements where the lawyer is afforded an opportunity to speak to a group of people.
To illustrate exactly how this rule might apply, at this point, it is necessary to recognize and distinguish among the different circumstances in which a lawyer may spread or contribute wrong information. This is the first context. The second context focuses on the manner in which the lawyer spreads or contributes this information, specifically whether the lawyer asserts it with an impression of reliability. Now, a lawyer might share information on a matter, the facts of which are not yet generally known or easily accessible to the public. Under the proposed rule, even if the information shared is actually or turns out to be false, the lawyer's mistake would not be punished. However, repeated instances of a lawyer asserting factuality so as to impress the reliability of the information he shares or contributes, which turn out to be false, may give rise to penalties. In a second instance, a lawyer might share or contribute false information on a matter, the facts of which are actually well settled or well known. Depending on how easily the lawyer could have accessed the actual facts, the lawyer's omission might amount to negligence. Repeated instances of this may give rise to penalties, beginning with a reprimand. However, if the lawyer asserted the factuality of the information he shares or contributes, so as to give the impression of reliability, when it was actually well known to be false, then the proposed rule would give rise to penalties. The rule would go so far as to impose a penalty even at the first instance. Finally, if the lawyer impresses the reliability of the information he shares or contributes, which was at the time well known to be false, and the information pertains to a legal matter as to be well within the scope of the lawyer's profession, then the proposed rule would give rise to even more serious penalties. Lastly, a lawyer might share or contribute information they know to be false. Depending on the contextual gravity of the assertion, such an act may be presumed to amount to fraud. Such an act would further be aggravated if the information pertains to a legal matter as to be well within the scope of a lawyer's profession. This knowledge on the part of the lawyer that they are committing this information would warrant serious penalties.
One of the concerns that may be raised regarding the provision is its constitutionality. Considering that this proposed rule directs lawyers not to spread disinformation or misinformation, this appears at first glance to be a possible limitation on the freedom of expression, a right embodied under Section 4, Article 3 of the Constitution. However, our proposed amendment does not violate this right, as it merely prohibits lawyers from engaging in forms of speech that are already considered not constitutionally protected. The case of Chavez versus Gonzalez provides that defamation, such as slander and libel, is not entitled to constitutional protection and may even be penalized. This is merely in accordance with the current laws that provide penalties for defamatory speech, Article 358 of the Revised Penal Code, which punishes slander, and Articles 353 and 355, which define and prohibit libel. We also have laws for libel committed through electronic means. Cyber libel is considered a punishable offense under the Cybercrime Prevention Act of 2012. Within our current context, especially in the wake of the 2022 elections, much of the defamatory language circulated online, on broadcast media, or even in person concerns the public and malicious imputation of a crime, vice, defect tending to cause dishonor or to discredit individuals. The proposed rule urges lawyers to address this by ordering them to mindfully uphold, even in their personal capacities, the laws which penalize false statements made about other persons, especially on digital platforms, where it becomes easy to forget about one's accountability to make honest statements and to ensure the truth of a statement before posting or sharing. As this is an expansion of Canon 7 of the Code of Professional Responsibility, and more specifically Rule 7.03, this creates another standard which lawyers should adhere to in their personal lives in order to uphold the integrity of the legal profession. It also serves to further underscore the duty of the lawyer to support the Constitution and obey the laws and promote respect for law and of legal processes under Canon 1 of the Code of Professional Responsibility.
Thank you. Our next group from the class of Professor Tadico, Ms. Bencho, Mr. Cinco, Mr. Lavinia, and Ms. Nang, transforming the court into a safe space, one word at a time. Presentation, please.
Good afternoon. We are excited to present our proposed provision on the Code of Professional Responsibility with our presentation entitled Transforming the Court into a Safe Space, One Word at a Time. Next slide, please. According to the World Bank's Women, Business, and the Law 2022 report, the Philippines scored a 78.8 out of 100 on legal and economic gender equality. The score has not changed since the previous year, and discrimination remains rampant at home, in the workplace, and in public spaces. There is still a lack of representation of women as managers, police officers, scientists, and they are still illustrated as domestic helpers, canteen helpers, vendors. LGBTQ plus members still experience prejudice and endure misconceptions that may harm them. This discrimination and inequality are reflected as well in the administration of justice. In a study conducted by attorney Mirna Feliciano, gender bias is manifested in courts in cases of double victimization, negative attitude towards female victims, gender insensitive rules and procedures, trivialization of gender crimes, and underrepresentation of women. Mindanao Pride board member Buhisan explains that these stereotypes even kill them. So our courts of justice must take steps in addressing this. How? The research managers in the Asian Institute of Management stress that we cannot fully realize empowerment by simply providing economic opportunities or simply creating more jobs for women. Instead, we have to look into the daily routines, the regular practices that perpetuate gender bias, and we can start by examining language, which is the vehicle in which the law administers justice. Prof. Kesabir from London Business School provides that the use of language reflects and influences perceptions of gender roles. In general, people are not conscious of the language that they are using, but there is a body of evidence that supports that the way people use gendered words, pronouns expresses not only their beliefs, but also shapes the world that they see them, also shapes the world and their place in this world. So language alters people's viewpoints, and it must be the duty of our courts to take the lead in promoting inclusivity and eradicating this bias that hinders the proper administration of justice.
Since this gender bias exists not only in the language used by the people in court, but also through other aspects of our other aspects such as our culture, it would take years, if not decades, before we could completely eliminate such biases. It would take so much time and effort, but we could start now. We could initiate this change by implementing the use of gender-sensitive language in all public and official dealings of lawyers. With this, the group proposes an additional rule under Canon 8 which states that a lawyer shall use language that is gender sensitive in all public dealings and official documents. Before we discuss the benefits of this change and how we could further execute the use of gender sensitive language, let us first look into its legal basis. One legal basis for such change is the fact that Philippines is a state party of the CEDAW. Compliance to this treaties calls for substantive equality. Substantive equality means that women have the right to full and equal enjoyment of all freedoms, which encompasses both equality in law and equality in results. So thus, the Philippines as a signatory has the duty to eliminate discrimination against women that arises from the use of language that is not gender fair.
So why is the current provision, the current Canon 8, not enough? Current canon, the current formulation of Canon 8 is not enough insofar as it only talks about the mere use of temperamental and professional language and conduct. This does not directly address the problem of disparities in the way that different genders are talked about in the profession. Our proposal is to explicitly call for the use of gender-sensitive language in the legal profession. Providing such a concrete provision would help remind lawyers that the world is moving towards a gender-sensitive path and that there is no more space for sexist or misogynistic language in the professional workspace. The direct beneficiaries of this provision would be women and other gender minorities, such as those belonging to the LGBTQ community, for whom the courtroom and other spaces within the legal profession would be a safer space. At the same time, this new provision would also make it easier for the judiciary to hold accountable members of the bar who use misogynistic or hateful gendered language.
So the question now is, how do we intensify the use of gender fair language in the professional dealings of lawyers? And this group proposes a twofold approach. So first is to adopt and expand the scope of AM number 06821 SC, which is a Supreme Court resolution regarding the use of gender fair language. And second, to integrate gender sensitivity training in the mandatory continuing legal education, otherwise known as the MCLE. So currently, government officials and employees are urged to use gender fair language in all communications, documents, and issuances. And this is so they may consciously avoid both implicit and explicit gender discriminatory language and to facilitate gender sensitivity in the bureaucracy. So the Supreme Court resolution mentioned earlier addresses justices, judges, and employees of the judiciary to use gender fair language. However, this group requests that the Supreme Court resolution be applicable to lawyers and to include suggestions on how to use gender fair language and examples of which kind of language to avoid. So first, how to use non-sexist language. So there are 5 examples here. So the first is to eliminate the generic use of he, his, and him, unless the antecedent is obviously male. Second is to eliminate the generic use of man. Instead, use people, person, human being, humankind. Third is to eliminate sexism in symbolic representations of gender in words, sentences, and text. And one way to do this would be to take the context of the word, analyze its meaning, and eliminate sexism in the concept. So an example of this would be, instead of feelings of brotherhood, you analyze the meaning of brotherhood and replace that with feelings of kinship and solidarity. Fourth is to eliminate sexual stereotyping of roles. And lastly is to eliminate sexism when addressing persons formally. So an example of this would be to use Miss instead of Mrs. So second is to include examples of which kind of language to avoid. So an example of this would be where Judge X used derogatory and irreverent language in reference to the complainant, calling her as only a live-in partner and presenting her as a mistress in an illegitimate relationship. So these remarks by the judge reveal his prejudice and lack of gender sensitivity. And these are remarks that not only judges should avoid, but lawyers should avoid as well in their legal profession. So the second part of the group's approach to intensify gender fair language, the use of gender fair language, is to integrate gender sensitivity training in the MCLE. So currently, all Filipino lawyers shall undergo MCLE every 3 years, and this is designed to ensure that lawyers keep abreast with law and jurisprudence. But importantly, it's also to maintain the ethics of the profession. And included in the ethics of the profession is to use gender fair language. Therefore, this group suggests the integration of gender sensitivity training as an education activity in the MCLE to increase awareness and deepen understanding of gender concepts and manifestations of gender bias and prejudice. And it's important to make this mandatory for all lawyers because we've seen in the past that where attendance is optional, attendance rates are generally low and they comprise of individuals who are already gender aware. So we want our target to be those who are not yet gender aware in order to deepen their understanding of gender bias and prejudice. So these are the options that this group suggests to intensify gender fair language in the legal profession. Thank you, everyone.
Thank you. On to our next group from the class of Professor Bonoan, Ms. Aguilar, Mr. Vega, Ms. Tatad, Ms. Bartolabak, and Mr. Chavez on the future of the practice of law, allowing fee splitting with non-lawyers in response to the evolving legal landscape of the 21st century. Presentation, please.
Good afternoon, everyone. We are Group 7, and our contribution for today's symposium is entitled The Future of the Practice of Law, Allowing Fee Splitting with Non-Lawyers in Response to the Evolving Legal Landscape of the 21st Century. Next slide, please. The subject provision that we would like to focus on is Rule 9.02 of the Code of Professional Responsibility, which provides that a lawyer shall not divide or stipulate to divide a fee for legal services with persons not licensed to practice law, except where there is a pre-existing agreement with a partner or associate that upon the latter's death, money shall be paid over a reasonable period of time to his estate or to persons specified in the agreement, or where a lawyer undertakes to complete unfinished legal business of a deceased lawyer, or where a lawyer or law firm includes non-lawyer employees in a retirement plan, even if the plan is based in whole or in part on a profit-sharing agreement. Next slide, please. In order to have a deeper understanding of Rule 9.02, allow me to discuss the purpose of this provision. So how did Rule 9.02 come about? The Philippines has a code of professional responsibility that borrows heavily from the American Bar Association's rules. For instance, Rule 9.02 was lifted from Model Rule 5.4 of the U.S. Model Rules of Professional Conduct. There are two main rationales provided to support the imposition of restrictions on fee splitting arrangements as reflected in Model Rule 5.4. First is the concern that a non-lawyer may impair a lawyer's professional judgment. The other one is the concern that non-lawyers who participate in fee splitting schemes will engage in the unauthorized practice of law. By analogy, these can also be applied in the Philippines. As such, Rule 9.02 is a facet of the rule against laymen from practicing law and exists to protect the independence of a lawyer's judgment. Expounding further, the long-standing principle of the prohibition is that public interest is better served when clients are assured that they are represented by lawyers who are not subject to conflicting interests or divided loyalties and are protected against possible control by others in the exercise of their professional judgment. In essence, the rule prevents the possibility where non-lawyers who are only interested in their own profit rather than the client's fate influence the judgment of the lawyer. Meanwhile, the rationale behind discouraging laymen from practicing law can be rooted to the fact that public policy requires that the practice of law be limited to those individuals duly qualified in education and character. This is to protect the public, the court, the client, and the bar from the incompetence or dishonesty of those unlicensed to practice law.
Okay, so now we move on to the issues with Rule 9.02. So while a lawyer's independent judgment is, of course, important, the group believes that there are major issues with 9.02. So first and foremost, its highly restrictive economic rules prevent lawyers from being accessible to those who need the most, which ultimately stifles the administration of justice. And second, the nondescript harm which Rule 9.02 seeks to prevent is heavily rooted in conjecture. Next slide, please. So according to a research by the World Justice Project, the Philippines currently ranks 84 out of 139 countries in terms of access to justice and affordability of civil legal services. So this is for the year 2021, and that only roughly 20% of Filipinos in the country are able to access legal help, leaving the other 80% without legal assistance. And why is this the current landscape of the legal industry in the Philippines? We believe that one of the most significant reasons for this is the restrictive regulations imposed by Rule 9.02. Next slide. So particularly, Rule 9.02 adversely affects the legal industry in two primary ways. So first, it gives legal providers limited access to capital. So law firms, which is where most lawyers usually end up in, typically earn profits from charging legal fees. So fees from, for example, consultations or representation in courts. And according to Rule 9.02, you cannot share these profits with non-lawyers, which means that non-lawyers are also prohibited from investing in law firms. And we believe that this ultimately leaves law firms strapped for capital and prevents them from expanding and making their services more available to the public. Secondly, Rule 9.02 is also serves as an obstacle for legal service providers to keep up with modern innovations in business practices. So in the United States, for example, several legal matchmaking services such as LegalZoom, Rocket Lawyer, Avo, they were all prohibited for violating ethics rules concerning fee sharing and the impairment of a lawyer's professional judgment. And this is despite the fact that a number of lawyers and clients have already benefited from this kind of arrangement. So in short, Rule 9.02 prevents productive collaboration between the legal field and other disciplines. It is counterproductive and stagnates innovation. And given these issues, there is a need for Rule 9.02 to be revised.
As such, we would like to present our proposed provision for the new Rule 9.02, and it is as follows. A lawyer shall be permitted to divide or stipulate to divide a fee for legal services with persons not licensed to practice law, provided that A, the client's informed written consent to the lawyer's fee-sharing agreement with a non-lawyer has been obtained. B, there must be no interference with the lawyer's exercise of independent professional judgment or with the lawyer-client relationship. And C, the fee must be reasonable. Next slide, please. So we now present the rationale for our revisions. So the institution of sharing fees with non-lawyers can result in the division of costs in litigation. Essentially, lower costs for the firms and the clients. Susskind, in his book, Tomorrow's Lawyers, introduced the concept of shared service centers. These centers would allow, in his example, for banks to collaborate with other banks and share the burden of costs in the work that has been accomplished. Our recommendation in this case is slightly different and more radical with that of Susskind, because what we want to allow is for the sharing of fees with lawyers and non-lawyers. We are also hinging our recommendation on the role of specialization in the division of work. Lawyers would share fees with non-lawyers as regards to share of the work that has been done in a specific case. Apart from the reduced costs in litigation, this change would also serve as protection for the clients from the dominant culture in so many commercial firms of lawyers to churn out as many billables as possible. This change would also allow for clients to see a more transparent appropriation of the fees and the breakdowns of the receipts and be able to determine where their money went to.
So now we go on to the topic of how this revision may affect future cases. And one of these cases are where smart contracts are involved. So basically, a smart contract is an agreement whose execution is automated. It is a digital program stored on blockchain that transfers digital assets between parties wherein certain conditions have been met. Among other things, a smart contract can take custody over and instruct transfer of assets, create and distribute electronic assets, synchronize information, and manage an identity and user access to software applications. With the proposed revision to Rule 9.02, lawyers would be allowed to hire programmers to set up smart contracts. This is beneficial for both sides, both the lawyers and the non-lawyers, because technological innovations incorporated into legal services would be convenient and efficient. More specifically, non-lawyers sharing legal fees with lawyers as opposed to merely being paid for their itemized services would benefit law firms by raising the equity capital needed to build and sustain their businesses, which can then prevent smaller firms from relying on debt and after-tax income. More importantly, technological developments would be impossible if there is no access for private capital to fund research. So, in effect, the ban on fee sharing among lawyers and non-lawyers would hinder innovation, which would be detrimental to the formation of new ideas and different perspectives.
Another significant effect of our proposal would be a more liberal approach to the attorney-client relationship. Under our proposed revision, non-lawyers may be able to access information would normally only be privy to lawyers. But as we said, as long as written consent is given by the client, the attorney-client relationship now extends even to non-lawyers regarding information specifically made available to them. Now, the possible risk that we've contemplated in this modern setup that we are proposing is the degree of accountability of non-lawyers in mishandling cases alongside lawyers. Obviously, the court is the one who will supervise erring lawyers. And because of this proposed revision, it will open doors for the courts to provide guidelines for this setup, wherein the non-lawyers can share legal fees with lawyers, also allowing for non-lawyers to have access to information with the attorney-client relationship. In conclusion, our group would like to amend Rule 9.02, which essentially we would allow the sharing of legal fees between lawyers and non-lawyers. Thank you for listening to our presentation.
Thank you. Now from the class of Professor Lim Ong, we welcome Mr. Asis, Mr. Anonas, Ms. Obogne, Ms. Sagandoy, and Mr. Tayag. Legal advice given through social media platforms. Presentation, please.
Good afternoon, everyone. In line with the symposium's theme of Rules for Tomorrow's Lawyers, our group will be discussing on the topic of legal advice given through social media platforms. So how did this come about? Since the onset of the pandemic, there has been a noticeable rise in the number of Filipino lawyers providing unsolicited legal advice through various social media platforms. These include Attorney Rani Libayan in his channel Batas Natin, the Chief Public Attorney of PAO, Attorney Persida Acosta, and also DLSU College of Law Dean, Attorney Chel Docno, just to name a few. So the issue here is whether legal advice given through social media platforms can be considered a valid practice of law. Should we call it out or keep it? So for the purposes of this study, legal advice is defined and shall pertain to the giving of a professional opinion regarding the law in relation to a particular situation. However, this study is limited only to the practice of law regarding online informal legal interactions and AMAs or Ask Me Anything. The merits of online lectures utilized for academic purposes will not be included, as this is already a practice employed by schools nationwide since the start of the pandemic.
Before we delve into the main issue, we first explore the pros and cons of using social media platforms for giving legal advice. As to the advantages, we note that the use of various social media platforms allows lawyers to make legal services more accessible to more people. Compared to the traditional means of obtaining legal advice, that is, by physically seeing a lawyer in his or her office, anyone who has a gadget connected to the internet can now access a wide range of online content addressing legal issues such as those pertaining to marriages, distribution of inheritance, change of names, among others. More importantly, these online content can be accessed for free and at one's convenience, thereby eliminating the two barriers commonly faced by people needing legal advice. Second, with the growing popularity of online legal content, more lawyers and law organizations have found effective ways to present highly technical legal materials using short, comprehensible videos. In turn, these help improve the layman's understanding of their rights under the laws. Lastly, for the lawyers themselves, social media platform allows them to enjoy airtime for free and reach more people who can also be their potential clients. To depict how popular online legal content has become, we pulled out some statistics from TikTok, one of the social media apps used by a number of lawyers to create and share online legal advice. As can be seen on screen, legal online contents in TikTok have gained not just thousands of views but hundreds of millions. On the other hand, we noted three disadvantages of using social media platforms for sharing legal advice. First, free legal advice accessed online is susceptible to misinterpretation. Compared to the traditional setup where lawyers and clients meet face-to-face to discuss certain legal issues in detail, in online contents, it's usually just the lawyer speaking his part, and thus there is limited opportunity for the audience to ask follow-up questions and make further clarifications. Second, online legal advice may not directly and fully address complicated legal issues given the limited information provided by people asking online. Thus, there is an inevitable tendency to leave out exceptions. Lastly, there is a risk that the general public will merely rely on free legal advice online and no longer consult actual lawyers for further guidance or clarifications.
Our group presents two issues that can be discussed regarding the topic. As to the first issue, it is best to distinguish legal information and legal advice. Based on the Ulat versus the legal clinic case, the two can be distinguished as to whether it falls under the practice of law. Providing legal information does not, while legal advice falls under it. Looking at other foreign jurisdictions' take on the issue, the ABA distinguished it based on content and context. With respect to context, the lawyers who speak to groups generally have been characterized as offering only general legal information, while with respect to content, lawyers who answer fact-specific legal questions may be characterized as offering personal legal advice. Moreover, the DC Bar has stated that providing legal information involves discussion of legal principles, trends, and considerations, whereas providing legal advice involves offering recommendations tailored to the unique facts of a particular person's circumstances. It is summarized as follows. As to the next issue, on when does an attorney-client relationship in cyberspace begin? Again, let's start with jurisprudence. An attorney-client relationship begins from the moment a client seeks the lawyer's advice upon a legal concern. Based on this controlling doctrine, we would initially presume that Q&As provided by lawyers on YouTube, TikTok, or Facebook, wherever the case may be, can already give rise to an attorney-client relationship. Based on an article published by Zuckerman Spader, a US law firm, when a lawyer provides legal guidance or advice in social media platforms, users might reasonably believe that they have an attorney-client relationship with that lawyer. As cited, the rule of thumb prescribed by the ethics opinion of the DC Bar is to avoid giving specific legal advice, as communication of sufficient particularity and specificity may give rise to an attorney-client relationship. Hence, it brings to bear all of the responsibilities and benefits of such relationship. Further, the DC Bar cautions that even the use of a disclaimer may not prevent the formation of attorney-client relationships if the party's subsequent conduct is inconsistent with the disclaimer. In light of this, the attorney-client relationships which may be formed by the setup may give rise to other ethical issues, such as number 1, the indirect advertising and solicitation, and number 2, the violation on the confidentiality of attorney-client relationship. The matters discussed should be noted to prevent any unsolicited attorney-client relationships and misunderstanding as to whether representation was already formed on the part of the person who sought the legal advice.
To continue our discussion, we ask the question, what other rules for social media are applicable? Now, we must remember that legal ethics applies whether you are active in traditional media or in social media. And the legal profession has continued to adapt to the innovations of the internet age, whether it was bulletin board systems, emails, blogs, websites, online consultations, up to the social media platforms of today. The legal practice has eventually caught up to the times. And because social media has such a broad reach, coupled with a feedback mechanism allowing for almost instantaneous methods to react, to reply, and to respond to each other, this uncontrolled interaction and immersion has to be properly guided to ensure that the code of professional responsibility retains its applicability to current online practices in social media. Previously mentioned concerns regarding client-attorney relationships, solicitation, and improper advertising may either be expanded or new canons and rules be made to cover the new realities posed by social media. Appropriate guidance and directions must be written to expound on what is permissible and what should be avoided in the usage of social media to maintain the integrity of the legal profession. With the advent of the pandemic, there's been a global shift to the online realm for most everything, including the practice of law. The pandemic forced innovation to happen at a rapid pace in an attempt to help alleviate the current situation that everyone presently faces. Now, social media has provided law practitioners a novel way to engage, educate, and empower the general public. But the usage of social media must never sacrifice justice or the practice of law simply for the sake of having more followers, more reach, or more influence. With the world moving towards a digital age, it is only a matter of time before the ethics of online legal practice might have to be suitably regulated. Due to the inherent capability of social media to provide an effective means of interaction and connectivity, some considerations must be contemplated in revising the Code of Professional Responsibility. Now, in order to help lawyers who use or are planning to use social media to engage and interact with the general public, in making the law more palatable and understandable to the common person, without sacrificing the legal profession's integrity and dignity, the CPR, the Code of Professional Responsibility, must be able to directly respond to the nature of social media.
For our group's recommendations, first, disclaimers should always be given.
Tracks. If you like my videos and you want to see more, please hit the subscribe button. Please remember that this is for educational purposes only and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Shout out, Tracks. If you like my videos and you want to
Disclaimers like these beforehand allow lawyers to avoid the risk of misinterpretation, of losing business, or becoming liable for violating the Code of Professional Responsibility for lawyers. Second, professionals should not give legal advice on social media that is very specific to a case. The reason for avoiding this is that answering with specifics could create an attorney-client relationship. So for advice given online, it would then be best to just stick to general advice and suggest that the one who posed the question should hire an attorney. This would also prevent the general public from no longer consulting with actual lawyers for further guidance or for clarification, as they might merely rely on the free legal advice that is given online that they could find. Third, a framework for the online practice of law with its implementing rules and regulations should be established. This could then be the roadmap for lawyers pivoting towards a more digital form of practice. It would significantly reduce the gray area in this space, and this framework would allow for clear-cut standards on how this unprecedented form of law practice should be done. That is all from our group. Again, we have discussed legal advice given through social media platforms. Thank you.
Thank you. Now, another group from Professor Lim Ong, Ms. Olado, Mr. Gozalo, Ms. Orticio, Mr. Enriquez, and Mr. Javier on plagiarism in the legal profession. Presentation, please.
Our topic is plagiarism in the legal profession. In general, to plagiarize is to steal and pass off the ideas or words of another as one's own, or to use another's production without crediting the source. Black's Law Dictionary defines plagiarism as the deliberate and knowing presentation of another person's original ideas or creative expression as one's own. In the legal context, the judicial system is not based on the originality of the writer's thesis but on the doctrine of stare decisis, which encourages courts to cite historical legal data, precedents, and related studies in their decisions. The judge is not expected to produce original scholarship in every respect. As ruled in the case, an act of plagiarism presupposes deliberate intent. Charges of plagiarism for honest work done by lawyers will not prosper.
Briefly going through the relevant canons and rules in the Code of Professional Responsibility, we first go through Canon 1. A lawyer has duties to the society, one of which is embodied in Rule 1.01 of Canon 1. It is incumbent upon a lawyer not to engage in dishonest conduct. Plagiarism in its essence is an act of intellectual dishonesty, and the lawyer owes a duty to the society not to engage in such acts. Next is Canon 10, specifically in Rule 10.02. A lawyer shall not knowingly misquote or misrepresent the contents of a paper, and so on. As an officer of the court, a lawyer is expected to maintain the integrity of information that is presented to the court. It was also held in Adas Realty Incorporated versus CA that the legal profession demands that lawyers thoroughly go over pleadings, motions, and other documents prepared by them. Such level of diligence is expected from lawyers in assuring the performance of their duties. And lastly, we have Canon 18, which provides that a lawyer shall serve his client with competence and diligence. None of the rules under this canon provide for a specific diligence required in making sure that no act of plagiarism is committed in the course of employment. However, in a general sense, a lawyer owes it to the client to deliver his or her legal services with full attention, skill, and competence. The diligence required is the same in safeguarding a client's interest as well as in assuring that the lawyer's duties are being performed according to ethical standards.
Having discussed plagiarism and the canons that deal with it, let's now look at the review of existing rules and jurisprudence in the country. Aside from the two definitions of plagiarism discussed, the concept of plagiarism also takes different forms in relation to the laws that punish it. These laws refer to Intellectual Property Code, E-Commerce Act, and Cybercrime Prevention Act. Under Intellectual Property Code, the act of plagiarizing becomes punishable if it amounts to copyright infringement. The punishable acts are plagiarizing copyrighted literary and artistic works and derivative works under Section 172.2 and Section 173. Secondly, we have the E-Commerce Act. Under E-Commerce Act, plagiarizing is punishable in the form of online piracy through the use of internet or other telecommunications networks, which constitutes a copyright infringement. And lastly, under Cybercrime Prevention Act, the act of plagiarizing constituting as copyright infringement is also punishable as committed through ICT networks or facilities like the internet. In this case, Associate Justice Mariano C. del Castillo was charged of plagiarism in his Venuya versus Executive Secretary decision. Attorney Harry Roque Jr. and Romel Bagares, the petitioner's counsel, claimed that the ponente Justice del Castillo plagiarized three sources. Number 1, article titled A Fiduciary Theory of Jus Cogens. Number 2, article titled Breaking the Silence, Rape as an International Crime. And lastly, the book called Enforcing Erga Omnes Obligations. According to the petitioner counsels, the source materials were twisted and used without proper attribution and made to look like they support the judgment's arguments, but in fact, they do not. So on the main issue of whether Justice del Castillo is guilty of plagiarism, the court held that he was not guilty. First, the Supreme Court prescribed a controlling definition of plagiarism as it presupposes that there's a deliberate conscious effort to steal another's work and pass it off as one's own. Therefore, it requires element of intent. Secondly, according to the court, Justice del Castillo had done an honest work by building his own analysis, formulating the issues himself, and discussing the laws involved. It is true, Justice del Castillo failed to attribute to the foreign authors the materials that he lifted from their works and used in the writing of his decision. But, as the court said, the evidence found the Ethics Committee that he had no intention to pass them off as his own because the earlier versions of the decision showed the attributions. And lastly, this case established that same rules must apply to practicing lawyers. Lifting passages from various writing and at times omitting without malicious intent attributors to the originators is not considered as dishonesty for the court. After all, the interest of society in written decisions is not that they are originally crafted, but that they are fair and correct in the context of particular disputes involved.
Before moving on with the canons,
let us briefly connect how plagiarism as an academic violation may transform into a legal issue. In general, plagiarism is not a crime per se, while it being considered a breach of honesty, integrity, and justice. However, legal action can be initiated on plagiarism if it involves copyrighted work as provided in our special laws. Outside the scope of these laws, the Supreme Court promulgated in the Del Castillo ruling that in order for plagiarism to be an actionable wrong, such must be done deliberately. Thus, negligence, good faith, honest mistake are valid defenses. Here is a quick overview of the canons touching on plagiarism as also discussed earlier. However, as will be discussed in the next slide, these may not be sufficient to completely address the issue on plagiarism. As observed in Rule 1.01, the issue on intellectual dishonesty is not directly addressed since this canon talks about dishonesty in a very broad sense. While Rule 10.02 discusses willful misrepresentation of contents, it actually focused on the willful use of inaccurate information, and plagiarism here is only impliedly or indirectly addressed. Canon 18 mandates competence and diligence in the service done by lawyers. However, it does not touch on the diligence required in attributing the works of others. While the canons indirectly recognizes plagiarism, they fell short of providing a proper standard to determine when plagiarism is an actionable wrong. In its simplest sense, plagiarism violates time-tested principles of honesty, integrity, and justice, yet the canons and even the High Court provide a rather relaxed standard when letting offenders off the hook.
Now we proceed with the recommendation. Our recommendation is that a new rule, Rule 10.04, be added. This provides that a lawyer shall strive for technical accuracy in his work and not commit any form of intellectual dishonesty. This new rule addresses the issues identified in the current canons by, first, explicitly providing that intellectual dishonesty in a lawyer's work is unacceptable, that a plagiarism-free work is the standard for lawyers. Second, that both malicious and negligent acts of intellectual dishonesty are now sanctionable. And then lastly, that the disputable presumption of malice holds in cases where intellectual dishonesty is present in a lawyer's work. In terms of execution, we recommend that graver penalties be imposed on cases of repeat and malicious intellectual dishonesty versus negligent or first-time cases. We also recommend that MCLE courses on prevention of intellectual dishonesty and the proper use of legal authorities be offered or reinforced.
Proposed Rule 10.04 attempts to address the limitations in the canons by being both preventive and proactive. Preventive, since mere addition of the canon, which explicitly targets intellectual dishonesty, would deter plagiarism. It is also proactive, since it encourages technical accuracy in the work and instills a sense of responsibility among the community to actively check upon the works of others. The suggested reinforced rules would also boost the preventive and proactive effect of the proposed canon. By providing graver sanctions on repeat cases of intellectual dishonesty, lawyers would be discouraged from engaging such practice. Also, including topics on intellectual dishonesty and proper use of authorities in the MCLE would promote a plagiarism-free work standard among lawyers.
Thank you. Our next group, again from class of Professor Lim Ong, Ms. Montes, Mr. Clemente, Mr. Ronquillo, and Ms. Daza, starting outward, liberalizing the dress code for lawyers in court. Presentation, please.
Good afternoon, everyone. Our group is composed of Mr. Clemente, Ms. Daza, Ms. Montes, and yours truly, Mr. Ronquillo, and we are now going to propose an amendment in the Code of Professional Responsibility about liberalizing the dress code. And this presentation is entitled Starting Outward, Liberalizing the Dress Code for Lawyers in Court. Together with me is my co-group member, Mr. Ernest King P. Clemente, to discuss all about our proposition. Take it away, King.
Thanks, JA. Canon 11 of the Code of Professional Responsibility states that
a lawyer shall observe and maintain the respect due to the courts and to judicial officers and should insist on similar conduct by others. Specifically, Rule 11.1 requires lawyers to appear in court properly attired. Several authors have also discussed and elaborated this rule in a restrictive way. Ernesto Pineda, for example, presented the view that the proper attire being referred to by the code is the traditional attire for male lawyers, specifically the long-sleeved barong Tagalog or coat and tie, while semi-formal attire for female lawyers. Ruben Nagpalo, on the other hand, cautioned that a sloppy or informal attire adversely reflects on the lawyer and demeans the dignity and solemnity of court proceedings. Furthermore, a lawyer who dresses improperly in court may be cited for contempt. While this definition is broad enough to consider all kinds of attire as long as it is proper, Philippine government offices and courts have been restrictive in implementing this rule through the issuance of various memoranda and other circulars. In fact, in many instances, the government imposed sanctions and penalties to those who failed to comply with the policies regarding dress code. Back in 2000, a rule on dress code was issued through a memorandum released by the Civil Service Commission prescribing the dress code for all government officials and employees. They were directed to wear office uniform or Filipiniana on regular days, while business attire and maong pants are only allowed during wash days, on the condition that it was accompanied with a proper collared shirt for men or an appropriate blouse for women. The Supreme Court then adopted the rules set by the CSC, but further specified what should be and should not be worn by lawyers and court employees. According to the Administrative Circular Number 42/2013, the Supreme Court enumerated a list of prohibited attire, including wearing of maong or denim pants, rubber shoes, collarless shirts, revealing clothing, short skirts, shorts, and pants. The circular also specified what constitutes appropriate office attire aside from the office uniform, which includes knee-length office attires and formal shoes. This became the prevailing dress code starting April 2013. However, wearing of office uniforms became optional due to the Office of Court Administrator Circular Number 157/2013. It was further supplemented by OCA Circular Number 250/2015, where it restricted the attires of judges to be in business attires at all times, apart from the office attire promulgated in the earlier issuances. In summary, lawyers are expected to be in a business or formal attire during the course of their work, especially in court. According to Jenny Bricker, the observance of a proper attire would not only give respect to the position of the court and the role of the attorneys, but it would also empower them to fulfill a better job in being lawyers for their clients in court. Indeed, a client would also prefer a lawyer properly attired in the business or formal attire to handle his or her case than someone who does not present himself properly as a lawyer. Going against the established norms and standards of the proper dress code is a ground for citing a lawyer in contempt. One example would be the case of Falsis versus Civil Registrar, wherein attorney Falsis came to court in casual jacket, cropped jeans, and loafers without socks. The court in this case was offended by what attorney Falsis has shown throughout the proceedings, and held that attorney Falsis acted as though he was unprepared and without knowledge of the decorum typical of a lawyer appearing in court. Due to this, he was then cited in contempt and admonished by the court. While it has long been established that dressing formally maintains the integrity of the court, the liberalization of today's profession and workplace led to other contemporary views as to what constitutes proper attire. With this, the group is of the opinion that it is high time to revisit this provision. The current implementation of Rule 11.1 is not in line with contemporary standards. In our opinion, the rule is broad and does not specify, so choices to one's clothing should not be limited. Hence, our group is in the view that there is a need to liberalize the rules on proper attire. If the courts were given the sole discretion to lay down the standards, it may unjustly limit the lawyer's freedom to express themselves. One can present himself properly without desecrating the integrity of the court. Moreover, it may be discriminating against those belonging to the marginalized sector. Not all lawyers have the privilege and financial capacity to afford clothing that would conform to the stringent rules on proper attire. We also believe that the determination of what is proper and decent is subjective and should require the use of contemporary standards. In some countries, there are various movements towards liberalizing the dress code in their respective practices. It is high time for the court to revisit its old rules and adapt to the demands of the society. In addition, one's clothes are not determinative of his or her capabilities, skills, and personality. Appearances should not be a ground for the favorability of a case, nor should it be a ground for tarnishing the reputation of a lawyer. Lawyers should be measured by their skills, not by the formality of their looks. Lawyers should also be allowed to dress comfortably and still appear as professionals in court. The court should at least let the lawyers express themselves and exude their own pride as attorneys by letting them appear as they want, except for those circumstances where such attire appears to be conventionally malicious and vulgar, thus offensive to the court and to the profession. Going back to the case of falsies, in our opinion, it is acceptable based on modern society standards. One's fashion style, may it be too elegant or otherwise, then a formal attire should not be misinterpreted to mean that it demeans the court. As long as the lawyer carries himself professionally, wearing appropriate clothing such as denim pants and collared shirts, then he should be free from admonition. In summary, our proposal is to add supplementary rules defining what factors are to be considered as proper attire. The first supplementary rule that we came up with is that a lawyer's outfit is deemed proper and presentable as long as it is not malicious and offensive to the integrity of the court. Secondly, a lawyer's proper attire can be determined by considering culture, identity, and circumstances of the lawyer himself. Finally, applying a more relaxed rule on the wearing of the prescribed court attire, even in the post-pandemic period, would benefit court employees, including lawyers, who are financially challenged and recovering from the effects of the pandemic. The re-evaluation of the rules on dress code should not be exclusive to the standards imposed on men and women, but should also cater to the needs of the LGBTQ lawyers as well. Finally, courts must revisit the rules laid down in relation to proper attire from time to time to ensure its applicability in contemporary times.
Thank you very much for listening to our presentation. Once again, our group is proposing for a liberalization of the dress code by proposing additional rules in the code for professional responsibility. Our group hopes that this proposition will reach out to the appropriate authorities and serve as a guidance in formulating the new code for professional responsibility. Once again, we thank you for listening to our proposition and may you have a great day. Goodbye.
Thank you. Next, we're having Mr. Castro, Ms. Delantar, Ms. Garcia, Mr. Beliano, and Mr. Villacampa, all from the class of Ms. Professor Tantuico, and to speak on adapting to the digital age, a lawyer's and the law firm's duty of continuous learning and the speedy administration of justice through the use of computer software, online meetings, and e-filing software. Presentation, please.
Good day. The title of our presentation is on Adapting to the Digital Age, a lawyer's duty of continuous learning and the speedy administration of justice through the use of computer software, online meetings, and e-filing software. Our group's presentation is focused on the amendments which will build the technological and digital capacity of lawyers. Law is amongst the slowest industries to adopt to new technology, despite the fact that technology not only helps lawyers, but actually it helps the courts in the speedy administration of justice. Even before the COVID-19 pandemic hit, there has been already a shift to the digital technology, and the pandemic has forced the legal industry to aggressively push for digital transformation. To concretize, there have been over 778,000 video conferencing hearings conducted. There also have been 112,760 persons deprived of liberty, 1,721 of which are children in conflict with law, released using the modality of video conferencing hearings. In addition, the Supreme Court has taken initiatives in gearing up towards the technological and digital shift. The court, in an en banc session, has conducted a knowledge sharing regarding information communications technology. Also, the Supreme Court aims to capitalize in using artificial intelligence to improve courts' operations, such as the use of technology in preparing transcript of stenographic notes and the digitizing of judgments rendered. With these initiatives by the Supreme Court, it is inevitable that lawyers should develop the necessary skills to adapt to the changes in the legal practice. Now is the time for lawyers to further develop technological and digital skills, to stay true to their duty to their clients, to be prepared and competent not only with the law practice but also in other skills useful for a lawyer. However, the shift for legal practitioners has not been easy because of the unfamiliarity with the new technology and softwares. Aside from the new technology skills, there are also new risks with regards to new technology. Nevertheless, the technological and digital shift will take place. Thus, it is important that the lawyers are equipped with enough skill and capacity to adapt. So here are our proposed amendments. So in relation to Canon 5, we propose to amend Bar Matter 850, Section 2. So our group proposes to add subparagraph G. So it states that at least 3 hours shall be devoted to new technology and digital skills. So this is for capacity development. So also our group proposes to amend the last subparagraph. The remaining 3 hours shall be devoted to such subjects as may be prescribed by the MCLE committee. So this is formerly 6 hours. So our group also proposed to add rules under Canon 18. So this is Rule 18.05. A lawyer shall utilize the most updated technological resources available at the time in order to assist in the speedy and efficient administration and disposition of justice. Another rule is Rule 18.06. So we propose to add that a lawyer shall be knowledgeable about the benefits and risks associated with the relevant technology, keeping in mind that the client's interests are paramount.
For proper interpretation of the additional rules, the group has provided the following definitions. First, the group defines technological resources as information application to design, production, and utilization of services and goods in organizing human activities. This definition was directly lifted from Black's Law Dictionary. Second, utilize means to make effective and practical use in a comfortable degree, allowing for some leeway in the use of such technology as to not hamper the performance of future lawyers at the cost of technological advancement. Third, available means relatively well known in the field and widely accessible, taking into consideration the lawyer's means, emphasizing that the use of such technology must be equitable and must be measured against the capacity of such lawyers to 1. Acquire technology given its mass use in the field, and 2. Consider the standing of the lawyer to actually procure or use such technology without undue disadvantage to his standing in life. Fourth, the phrase at the time refers to the time at which the lawyer started the litigation or legal service and could have reasonably and competently used in the performance of his function as a legal consultant, representative, or any other function of his law practice. This phrase is meant to protect lawyers from violations due to nonsensically requiring them to use such technology which was not available to them when they started the service. Requiring lawyers to transfer and apply new technology while in the middle of legal services may be counterproductive.
Under the proposed Rule 18.06, we have the following key terms. To be knowledgeable means to acquire the degree of learning required for the certificate of compliance to be rewarded as determined by the authority conducting such training sessions and evaluations. The level of learning regarding technological skills referred to here are those relevant to the practice of law, as also determined by the accredited provider of mandatory legal education and approved by the MCLE committee. The term benefits here refers to the gains and advantages that arise from the use of technological resources that may be acquired in order to pursue the effective and efficient handling of the client's case. And finally, the risks pertained to in this provision are those disadvantages, liabilities, and costs that may arise from the use of such technology, which include but are not limited to considerations regarding data privacy, data security, and other relevant technological breach and breakdown.
We now discuss our group's amendment specifics or how to implement this amendment.
The Supreme Court, as part of its role to promulgate rules on pleading and practice and to maintain the high standards and competence of lawyers, must take advantage of the digital shift by incorporating new technology and skills in the mandatory continuing legal education, or MCLE, of lawyers. Since the MCLE is now also being conducted online, it should also include a skills workshop on technology for the legal profession. This will hopefully improve the technological competence of lawyers and enable them to become better practitioners to take advantage of this new technology. We highlight a few of the legal skills or technological skills that lawyers need to acquire in our proposal. First is legal writing and research. This includes basic mastery of word processing software such as MS Word, MS Office, MS PowerPoint, or MS Excel, as well as using online case catalogs such as CD Asia for legal research. Proper way of citing legal resources should also be mastered. Next is data privacy and security. Data and information privacy is also an issue that needs to be addressed, as the client attorney confidentiality should extend to keeping the client's digital file secure. Next is media literacy. Responsible social media use for lawyers should also be emphasized since lawyers have to maintain proper decorum and language fitting for a member of the bar even when posting on social media sites. E-litigation, meanwhile, refers to conducting trials or hearings via video conferencing. Since the pandemic is still ongoing, lawyers should get used to video conferencing as a way of conducting trials as the new normal. Pleadings and appeals are also being filed via e-copies or emails. Lastly, knowledge management. A lawyer should be able to keep his digital files secure and organized and easy to access. This includes e-discovery or discovery of evidence using electronic and digital files.
Per our proposed amendment to Bar Matter 850 and the MCLE Committee will plan and facilitate legal education activities dedicated to training lawyers on new technology and digital skills. While these skills will transform over time, our recommendation is to focus on the following topics which are currently relevant in legal practice. First, online conferencing platforms such as Zoom, Google Meet, and Microsoft Teams have become integrated into regular litigation and business correspondence after the COVID-19 pandemic. The Supreme Court has already institutionalized the use of Microsoft 365 and MS Teams to digitize work practices and conduct online hearings, as per AN number 2012-1SC. Legal education activities, therefore, must focus not only on the competency of lawyers in the use of such applications, but also on the rules on decorum, procedure, and evidence in relation to online hearings and court appearances as mandated by the Supreme Court. Second, database management, electronic filing, and cloud storage optimization will also be tackled through the commonly used cloud storage platforms such as Google Drive, Dropbox, and OneDrive. The risks of uploading confidential documents and the rules on electronic evidence will also be discussed, as well as skills training on data security protocols. Third, Microsoft 365 applications and services will also be explored. Particularly, the features of Microsoft Word will be discussed and demonstrated based on their possible applications for legal research, such as the use of citation tools, collaborative editing, and privacy and security features, among others. Other topics and technologies may also be chosen and discussed by the MCLE committee as the need or relevance arises. This concludes our presentation. Thank you for listening.
Thank you. Now we go back to class from Professor Banyes, Ms. Bello, Ms. Flores, Mr. Mangaya I, Ms. Mercado, and Ms. Santos on integration of social media platforms in making public statements regarding a pending case. Presentation, please.
Hello, everyone. We are students from the University of the Philippines College of Law, taking up Law 120, the legal profession. My name is Gio Mangayaay, and together with Samantha Bello, Francesca Flores, Diane Mercado, and Abigail Santos, we are Group 3, and it is our pleasure to deliver our presentation for today's symposium entitled Prejudicial Publicity in Social Media, Making Public Statements Regarding a Pending Case. Our presentation is focused on Canon 13, Refrain from Acts Giving Appearance of Influence, Specifically, we are commenting on Rule 13.02, which provides that a lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against a party. We believe that this rule needs to be contemplated taking into consideration just how pervasive technology and social media are in our daily lives. The legal system is not spared from its effects and influence. The delivery of news and commentary has now been expedited, with information reaching thousands, if not millions, of consumers in a matter of seconds. The power of social media to influence ongoing cases can be swift and powerful, as showcased in the case of Walmart versus Shank. Because of the tremendous pressure from online platforms, Walmart caved into the pressure during the case and changed its position, allowing Shank to keep the money they had initially filed the case to take from her. It is paramount that a lawyer must not contribute to the trial by publicity that cases, particularly the high-profile ones, are often subjected to. Locally, the Supreme Court issued a gag order to counsels and parties in the writ of Kalikasan case for the protection of marine resources in the West Philippine Sea after both parties made public statements about the case, which stemmed from the fishermen from Palawan and Zambales disowning the petition. The Supreme Court en banc reminded the counsels that they are prohibited by the Code of Professional Responsibility and the Rules of Court from litigating their cases through media or social media. Infractions shall be dealt with severely.
Beyond the traditional modes of delivering public statements, through television or newspaper interviews, delivering quick statements through a social media account, including but not limited to a Facebook post or tweet, is entirely possible. For example, in the US, the court denied a restraining order to prohibit lawyer Michael Avenatti from speaking to the press regarding his client's lawsuit against President Trump. So this took place during the pendency of the case Clifford versus Trump, which was a highly publicized case involving Trump's affair with the adult film star Stormy Daniels. The restraining order was filed by Michael Cohen, Daniels' lawyer, after Avenatti had made dozens of television appearances, hundreds of tweets, and various communications with the media over the months during their trial. However, the court denied the application for the gag order. According to the court, Cohen had not demonstrated in the application that immediate irreparable injury would occur in the absence of emergency ex parte relief. Despite Avenatti's explicit comments regarding the trial, the court said that it must first be demonstrated that Mr. Avenatti's statements are substantially likely to impact his right to a fair trial in this action.
It is important to note that a lawyer is bound by ethical obligations to society, courts, and clients. Engaging in pretrial publicity by giving comments on social media defeats such obligations. Exercising restraint from posting information on an ongoing case is essential in ensuring that there will be no external influences from social media that would be detrimental to one's client and the current case at hand. Preserving the impartiality of the judicial process and ensuring that the right of a party to a fair trial, unaffected by extrajudicial statements, is the essence of the Rule 13.02. This was showcased in the case of Enrico Velasco versus attorney Berteni Causing. In this case, attorney Causing had been suspended from the practice of law for 1 year by the court for divulging information on a current case he was handling, as well as insulting the opposing party through public posts. In his defense, he claimed that he was merely exercising his right to press freedom as a journalist blogger. The court stressed that this was a breach of his duties under Rule 13.02 of the CPR, as he not only disclosed confidential information regarding the nullity case, but also included his own strongly worded opinion regarding the complainant's character and the circumstances surrounding the case. The court then made their stance on the duties of a lawyer, both inside and outside of the court, clear. First, a lawyer is not allowed to divide his personality as an attorney at one time and a mere citizen at another. Regardless of whether a lawyer is representing his client in court, acting as a supposed spokesperson outside of it, or is merely practicing his right to press freedom as a journalist blogger, his duties to the society and his ethical obligations as a member of the bar
remain unchanged.
Currently, Rule 13.02 only suggests a prohibition of a lawyer from actively or directly making public statements during the pendency of cases. Although jurisprudence confirms that social media is well within the scope of the rule, it does not cover instances where lawyers passively or indirectly make public statements, especially on social media, through the acts of sharing or reacting to posts or comments made by third parties. This gray area presents ethical problems for lawyers that can possibly lead to a violation of the existing rule. Moreover, making public statements through the aforementioned passive acts impairs the essence of the rule because it has the potential to impact public perception and even heighten public condemnation of the accused in pending cases, especially for criminal trials. Take, for instance, a lawyer counsel for plaintiff who positively reacts to a third party's post relating to his pending high profile criminal case, wherein that post contains content that arouses public opinion against the defendant, can be perceived as the lawyer supporting the statement and can be considered as an indirect public statement in itself. Although a simple reaction to the third party's post seems harmless, it cannot escape the prying eyes of social media users searching for intrigue. In the worst case scenario, the criminal case may yield to a trial by mob rule, thus defeating the proper administration of justice. Hence, a new rule covering passive or indirect public statements should be constructed, since there are now various ways that a lawyer can express criticism on social media apart from explicitly making public statements.
With all these in mind, our group recommends expanding the existing Rule 13.02 as well as constructing a supplementary rule to address the passive acts of engaging with social media posts, which would tend to arouse the same effect on public opinion for or against a party. Thus, here is our revised formulation as follows. For Rule 13.02, a lawyer shall not make public statements in the media, which includes, but is not limited to, print, broadcast, and social media platforms regarding a pending case tending to arouse public opinion for or against a party. And as for the constructed supplementary rule, a lawyer shall not engage with posts and statements regarding their pending case through their social media accounts. Aside from preserving the legal professional conduct, these revised rules strike a balance between the constitutional right to a fair public trial and the impartiality of the judicial process on one hand, and each lawyer's right to freedom of expression on the other. These rules apply only to a pre-trial publicity during the pendency of a trial proceeding that a particular lawyer is currently involved in. As such, a lawyer is able to avoid generating or partaking in material prejudice in an otherwise supposedly impartial adjudication. And that concludes our presentation. This is Group 3 from BGC Day 1, and thank you so much for listening.
Thank you. Now we have another group from Professor Banyas, Ms. Abergos, Mr. Juan, Mr. Lagon, Mr. Panes, Ms. Kizon. Publicizing pending cases, revisiting Rule 13.02 of the CPR. Presentation, please.
Good day, everyone. We are from BGC Ibuan, and our topic or presentation for today is publicizing pending cases, revisiting Rule 13.02 of the Code of Professional Responsibility. Our presentation reviews Canon 13, Rule 13.02 of the Code of Professional Responsibility, which prescribes publicizing pending cases in a manner that tends to arouse public opinion for or against a party. Rule 13.02 of the CPR provides that a lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against a party. Our examination determined gaps in the current version of the rule, and we are also proposing recommendations which aims to address the gaps and shortfalls of the current rule with the view of enforcing its purpose and keeping its relevance in the changing times. In the age of social media, people tend to create or form their own biases based on information regarding cases that are being publicized. In a highly publicized trial, think of Depp versus Heard, which was recently concluded in the United States. People tend to share their biases and form their conclusions even though they have only seen a snippet of the trial. Similarly, in the Philippines, lawyers who make statements or insights on the pending cases, especially those highly publicized ones, may also produce such impact on the perception of the public, whether it is to form a bias against or for a party, or even a discontentment as to the ruling of the court. In Food Spear versus Mauricio, the court stated that the power of the media to form or influence public opinion cannot be underestimated. Even simple statements made by counsel or lawyers in general may have a huge impact as to how the public perceives the parties of the case, or worse, how the public will perceive the judicial system in the Philippines. It is evident that Rule 13.02 of the CPR was created to highlight the importance of ensuring that the public's opinion, as far as the lawyers involved can control, will not be a hindrance to the administration of justice. In our presentation, we will discuss how Rule 13.02 is considered too broad and how it restricts lawyers to exercise their freedom of expression. We will also propose changes on the current rule for it to be able to adapt to the current societal landscape. After studying Rule 13.02, we have summarized our critiques into 4 points. First is that the scope is too broad as it covers lawyers making public statements regarding a pending case. It does not identify if the lawyer being mentioned in this rule only covers those who are directly or indirectly related to the pending case. Number 2 is that the rule is unreasonably strict in explicitly prohibiting lawyers to make statements that arouse public opinion. Public statements made that are factual may tend to arouse public opinion in favor of a party. Under this rule, a lawyer making such statements will be penalized even if they have no evil intention of doing so. Next is that the rule is unclear as to what constitutes media and public opinion. And lastly, the rule is outdated and should adapt to the contemporary semantics of what media is. So the next presenter will discuss the critique on Rule 13.0.
So for our first critique, this provision is too broad as it does not distinguish what lawyer it refers to. So this rule does not differentiate between lawyers who are directly engaged in a pending case and lawyers in general. So only relying on this general definition exposes a risk of being too broad, which will technically allow lawyers who are not involved at all to unnecessarily be wary about making public statements about other cases even if they're not involved in them. So our group chose to apply the overbreadth doctrine in principle to form this critique, even if it's normally used in constitutional provisions to tackle ones that unnecessarily sweep its subject broadly. We find that this also applies to this rule, and we think that it is also too broad. For the next critique, on the strict prohibition in making public statements, it is our view that Rule 13.02 is unreasonably strict in explicitly prohibiting lawyers to make statements that arouse public opinion. Should a lawyer who is only stating facts regarding a case be found in violation of this rule? Moreover, should lawyers making statements regarding a pending case without the intention of maligning any party thereto also be penalized under said rule? To answer these questions, we look at some definitions of what public statements are in Philippine jurisprudence. Public statements, as defined in Velasco versus Kausing, are those that disclose confidential information regarding the nullity of the case, which also included the lawyer's own strongly worded opinion regarding the complainant's character and the circumstances surrounding the case. Another definition, which provided that public statements are those that will stoke the fires of public dissension and pose a potentially dangerous threat to the administration of justice.
So on to the next critique. So third, on media and public perception. Apart from the earlier cited case of Food Spear versus Mauricio, we believe that the role played by public perception in shaping public opinion is also recognized in other cases, such as in Lehana versus People, where Justice Brion, in his supplemental opinion, stated that justices and judges are not immune from the pervasive effects of media. Citing another case, Justice Brion proceeded to mention that it might be partial to build around justices and judges an impregnable armor against the influence of the most powerful media of public opinion. So it is clear that Rule 1302 first acknowledges the role that the media plays in shaping public perception, and second, ensures that lawyers play no part in shaping the same. However, maybe making public statements to the media is only one of the many possible ways to influence the public's perception. We believe that simply creating a prohibition on a specific act will not solve the problem that was intended to be solved in the first place. Perception has been weaponized and taken advantage of with the technological advancements of the modern era by allowing individuals to access information like never before. And beyond access, Even the creation, dissemination, and at times modification of information has been so much easier to perform by any person with access to the internet. Lastly, we critique Rule 1302 by saying that it has to adapt to the current version of what the media is. So the phrase in Rule 1302, which states that lawyers shall not make public statements in the media, we believe that this does not completely reflect our current understanding of what the media is. What the rule aims to avoid is the prejudicial publicity of pending cases arising from statements made by lawyers. However, in our current times, we have observed how information freely circulates in all forms of communication, especially on social media platforms. And even without the participation of lawyers, publicizing pending cases is more likely. Lastly, lawyers who want to stir up public opinions can simply utilize other methods to achieve their goals, such as creating bogus accounts or instructing someone else to do so. So it is so simple to get around the Rule 1302 at present.
For our recommendations, we have four recommendations in changing Rule 13.02. The first one is to limit the applicability of said rule to those lawyers only directly involved in pending cases. Second would be to make the rule not strict in prohibiting lawyers from making public statements, but only to discourage them. Thirdly, we would want to specify that Rule 13.02 should pertain to online and offline media, and that the primary purpose of making such statements should be to arouse public opinion. And lastly, we recommend the adding of the phrase, lawyers shall not participate in the spread of false information regarding any pending case, which we think is more applicable in this case. For our first recommendation, the applicability of Rule 13.2 should be limited only to lawyers who are directly involved in pending cases. This would explicitly exclude lawyers who are making public statements in independent capacity, such as lawyers being interviewed for their expertise and legal opinion, and lawyer journalists making a fair and true report on pending cases they are covering in their line of work. Secondly, preventing lawyers from speaking in the media or being strict in prohibiting them from making any public statements will not be appropriate for two reasons. First, there's too much vagueness regarding what exactly constitutes statements that tend to arouse public opinion. It would be unfair for lawyers to be put in a position where their statements may be used against them despite not having any intention to arouse public opinion. And secondly, there's no point in strictly banning lawyers from making public statements to the media, since with today's modern advancement, even if lawyers avoid the media at all costs, any person can garner the attention of the public in various ways. And lawyers can easily spread information regarding a pending case by simply delegating the action to someone else. Thirdly, we propose to specifically include both online and offline media. This would pertain not only to traditional print or broadcast media, but also to novel online platforms such as social media or social networking sites, blogs and video and audio platforms, among others. And lastly, we recommend adding the line, a lawyer shall not participate in adding the spread of false information regarding any pending case. We think that it is unnecessary to regulate lawyers' public utterances in order to arouse public opinion. The focus of this rule, however, should be to prevent the distribution of misleading information in the media that would somehow sway public opinion in the negative direction.
For the conclusion, Rule 13.02 falls short in its aim to prevent prejudicial publicity of pending cases. The means by which this rule regulates the actions of lawyers is inadequate and irrelevant, and at the same time imposes unnecessary restrictions on lawyers. By broadening the coverage of media in Rule 13.02 from both offline and online platforms, it will not only be restricted to the traditional media, but will also cover blogs, social media posts, and other content posted online. By including online platforms, it posits that the Code of Professional Responsibility is adaptable to technological advancements as well as societal changes. So thank you for listening to our presentation.
Thank you. Now get a group from class of Professor Bonoan, Miss Lee, Miss Naknak, and Mr. Kimwo on strictly professional, ruling out romance in the context of attorney-client relationship. Presentation, please.
So, Canon 15, a lawyer shall observe candor, fairness, and loyalty in all his dealings and transactions with his client. Next is Rule 15.01. A lawyer, in conferring with a prospective client, shall ascertain as soon as possible, ascertain as soon as practicable, whenever the matter would involve a conflict with another client of his own interest, and if so, shall with forth inform the prospective client. So first and foremost is our comment that there is a lack of regulation regarding lawyers engaging in relationships with clients. Now, many jurisdictions abroad have regulations disallowing clients, among other professionals, from engaging in romantic relationships with their ongoing clients. To allow such may hamper professional relationship between the lawyer and his client. Now, in the Philippines, there is a lack of regulation regarding lawyers engaging in romantic relationships with their clients. Philippine jurisprudence mainly tackles issues of lawyers partaking in illicit third-party affairs. However, there is a want of cases that refer to romantic romances between the lawyer and his or her client. Second, next slide, please. An intimate relationship between a lawyer and their client may create a conflict of interest. Now, this conflict of interest is personal in nature and may arise from the formation of an intimate romantic relationship between the lawyer and the client during the subsistence of their professional relationship. Now, first, the budding relationship may pose a distraction to the lawyer because he or she must now navigate between two paths, professionally and intimately. And now to maintain healthy relations with the client, having to juggle more issues may be detrimental to the primary professional relationship. At the same time, the lawyer may use confidential information disclosed to him or her by the client in a professional setting. This means that the client may not have necessarily disclosed such information otherwise or in a different setting as means to further up personal relationship. Now, this poses a risk as the lawyer may have a level of ascendancy over the client, which may be unduly used. This may potentially harm the client who sought the help of the lawyer in his or her professional capacity for legal advice or assistance.
Hence, it is suggested that under Canon 15 of the Code of Professional Responsibility, a new rule should be included, which will state that the lawyer shall not engage in an intimate romantic relationship with the client. And if one does subsist during the period of legal representation, the attorney-client relationship should be terminated. And this rule excludes relationships that predate the initiation of the attorney-client relationship. Also, it is proposed that Rule 1501 of the CPR be amended to make it gender neutral. So it will be that a lawyer, in conferring with the prospective client, shall ascertain as soon as practicable whether the matter would involve conflict with another client or the lawyer's own interest, and if so, shall forthwith inform the prospective client. So the new rule, this suggested rule, shall act as a safeguard to protect the lawyer-client relationship. The practice of law is imbued with public interest, and as a member of the bar, the lawyer is expected to uphold the integrity and dignity of the legal profession at all times. Hence, any conflict of interest which might hamper the public's trust and confidence in the administration of justice should be eliminated. Also, a lawyer should be mindful of the trust and confidence reposed in him or her by his or her client. So, as discussed, the nature of the attorney-client relationship is fiduciary. So, it anchors on the expectation that the communication between the lawyer and the client shall be strictly professional. So, any emotional involvement may presents a danger in the exercise of sound, independent, and professional judgment and conduct. It must be noted that under the suggested rule, it excluded relationships that predate the initiation of the attorney-client relationship. Pre-existing relationships, such as spousal relations, are excluded because of the assumption that such relationships are consensual. So unlike romantic affairs initiated during the attorney-client relationship, there is an assumption in pre-existing relationships that the lawyer did not take advantage of the client's trust to pursue an intimate connection. So the foundation in such relationships is outside the boundaries of professional responsibility. So it poses no risk on the professional relationship that is being protected. But it is worthy to note that even though these kinds of relationships are exempted, a lawyer should still be wary of any conflicts of interest that may harm the interests of the client or the legal representation. So, regarding the constitutionality of the recommendations, the suggested rule addresses legitimate interest, complies with the Equal Protection Clause, and promotes public interest. So, first, it addresses a legitimate interest. So the suggested rule serves a legitimate purpose, which is to avoid any conflicts of interest that a romantic relation between a lawyer and his or her client during legal representation may foster. So this is to preserve the integrity and efficiency of the legal profession and protect the client from potential exploitation. Further, it is also to prevent the erosion of public trust and confidence in the administration of justice, and to protect the client who relies on the legal competence of his or her lawyer. So, to reiterate, the practice of law as a profession is imbued with public interest. So, it also complies with the Equal Protection Clause because it creates a valid classification because it concerns lawyers and their clients. So, it has substantial distinction between lawyers and non-lawyers, clients and non-clients. Also, it is related to the purpose of the rule, and it's not limited to existing conditions. It could happen the existing conditions or the conditions could happen in the future. And lastly, it applies to equally to all lawyers and all clients, regardless of status or possession. And it specifically zooms into romances that happen between a lawyer and a client during their professional engagement and exempts pre-existing relationships. So again, to reiterate, the profession of lawyering is imbued with public interest. So, given the lack of regulation and the conflicts of interest when it comes to lawyers that engage in romantic relationships with their clients, a new rule should be put under Canon 15 of the Code of Professional Responsibility. So, lawyering is imbued with public interest, and as such, any actions that could diminish the faith the public has with their professionals must be eliminated. Not only would doing so eliminate conflicts of interest between the client, their lawyer, and the public, it would also cease any emotional attachment the lawyer and client could form, which could hinder the lawyer from properly executing his duties to his client. While forming this new rule would not completely end the practice of relations between a lawyer and a client, the regulation would limit such acts from being committed, ensuring that upholding public interest would come first. So this is the end of our presentation. Thank you, and we'd like to wish everyone a good afternoon.
Thank you. And now a group from Professor Lim Ong, Ms. Estopin, Ms. Menjola, Mr. Gan, and Mr. Custodio on the price of tomorrow, inflation proofing legal compensation. Presentation, please.
Okay, so hello, good afternoon, everyone. We're we're a group from BGC Eve 2, and we will be discussing the inflation proofing of legal compensation. Next slide, please. Okay, so Rule 20.01 under Canon 20 currently serves as a guide for lawyers in determining reasonable compensation for their services rendered to clients. The fee is reasonable if it is within the capacity of the client to pay and is directly commensurate with the value of the legal services that are rendered. For it to be considered unconscionable, the amount contracted for must be such that no man in his right senses would offer it on one hand, and on the other hand, no honest and fair man would accept it. Next slide, please. Inflation is defined as the general increase in the prices of goods and services in an economy. To put this differently, It is the decrease of purchasing power of money given the higher prices of goods and services. It affects the real income of any and every individual comprising the economy as it impacts the cost of living as well as their ability to avail of basic sustenance. In the Philippine setting, inflation is measured by the Consumer Price Index or the CPI, which has grown by close to 20% annually over the past 20 years. The following table shows the Philippine inflation trend over just the past 10 years. Current data shows that the latest year-on-year inflation figure is at 4.9% for the month of April 2022. The main drivers for the high inflation print were the rising oil and electricity prices, which in turn pushed up the cost of other commodities by pushing up their production costs. In view of elevated inflation, as well as the probability of higher personal taxes in the coming years in light of the DOF's proposal to the incoming administration, which is specifically to increase personal taxes to answer for the COVID-related debt by the Philippines, which was incurred, a review of the current factors considered in determining a reasonable lawyer's fees is sensible. The existing safeguards ensure fair and reasonable compensation for legal services, protect the client from fee overcharging. However, at the same time, protection for the lawyer, particularly for his right to be compensated fairly, must also be embedded in the canons of the legal profession. Any counsel that is worth his salt should be entitled to full compensation for his services because his capital consists not solely of his brains and skills, but it was also acquired at tremendous personal cost, not only in money, but also in his expenditure of time and energy. Based on the foregoing, we propose to include the inflation rate as one of the factors that have to be considered in determining the reasonable lawyer's fees. While the practice of law is neither a trade nor a business, but is instead a profession, it is only equitable to protect lawyers from economic factors that may affect their ability to provide for his or her own basic sustenance, such as food, water, and shelter. A lawyer, as with any other individual, needs to provide for his or her basic needs. The requirement expands if the lawyer is also the breadwinner of his or her family, which makes him or her responsible not only for his or her own needs, but also of the people who are dear to him or her. The worst possible scenario will be for a lawyer who is not able to answer for his or her own basic needs, which would make him rely on others. The legal profession requires the highest level of integrity and dignity, which certainly will prove to be challenging if the lawyer appears to be unable to take care of himself or herself. Reasonable remuneration needs to be determined from a 360-degree view, maintaining the competitiveness of compensation for lawyers, which would uphold the overall nobility of the profession. Economic factors, such as inflation, should be considered in this equation. The Corruption Perception Index ranks countries around the world based on how corrupt their public sectors are perceived to be. The results are given on a scale of 0 to 100, where 0 is highly corrupt and 100 is very clean. The Philippines' current score on the said system is 33 points out of 100. Undeniably and painfully, corruption exists in the Philippine system. While this measure talks about the perceived corruption in the public sector, the legal system is not isolated from the public sector. The law does not operate in a vacuum. In fact, corruption in the legal system is not unheard of. In 2012, Transparency International published an article on integrity issues related to lawyers and law firms, where Nicola Bonucci, chair of the IBA Anti-Corruption Committee, explained that in today's difficult economic climate, some law firms may tend to cross legal lines in order to obtain business. Economic incentives may curb corruption. In a study published in 2015 on the relationship between low pay and intention of corruption in the Cambodian public sector, data on the annual basic pay of political leaders in Asia show a negative correlation between the salaries of public officials and corruption. This table, as quoted in the mentioned study, is shown here for reference. In general, places where civil servants earn higher salaries display a lower level of corruption. Lastly, we believe that protecting reasonable compensation for lawyers will also encourage individuals to join the noble legal profession, thereby expanding the network of the so-called officers of the court, whose primary duty is the administration of justice. Over the years, interest in the legal profession has declined. In the Philippines, there is roughly one lawyer for every 2,500 people. This trend is summarized in this chart for reference. The competitiveness of the potential income from practice will naturally encourage others to view the practice of law as a reasonable profession. To summarize, our point is to include inflation as one of the factors in determining reasonable compensation. Thank you for your time.
Thank you. And that's our last presentation, unless I think that's the last presentation in our schedule. Thank you. This has been the Rules for Tomorrow, a symposium on the proposed revisions to the Code of Professional Responsibility. Again, the Institute for the Administration of Justice would like to thank, of course, its director, as well as the classes under which participated in today's presentations, the classes of Professor Bonoan, Professor Lim Ong, and Professor Tan Tuico. We'd also again like to thank our earlier lecturers, Professor Hardelesa, Attorney Bagilat, Professor Esguera, as well as Professor Dio. Thank you everyone for your presentations.